Any further? I have a speaker's list. So.
Yeah, I'm on the speaker's list, so I think we should go in the order that it was been received. So that would be Mr. Lawton, I think, is recognized before me.
Well, I actually don't have you on the speaker's list. Would you like to get back on it?
Sure.
Okay. All right. Okay, so Mr. Lawton, you have the floor.
Thank you, Chair. With respect to Mr. Brock's sub-amendment, I think it's clear that there is a lot of divisiveness surrounding C-9, a lot of complexity. The fact that we now have a sub-amendment on the table, I think, reinforces that this committee should be dealing with far more pressing priorities. I move that the committee now proceed to the consideration of Bill C-14, the Bail and Sentencing Reform Act.
We have dealt with that, ruled on it at least twice today.
Point of order.
So we're not going to do it again.
Point of order.
Yes, Mr. Lawton.
We are now on a sub-amendment. The context in which this discussion arises is entirely different now. I don't think you should be blocking your own Liberal colleagues from allowing them to move their bail legislation
The committee now
forward.
So let me get this straight. Your sub-amendment makes it less important to deal with the legislation we're dealing with, just to be clear?
The sub-amendment
okay,
shows
I got it. Anyway, I've made my ruling. That's final. Challenge, okay, that's your right.
Mrs. Latencio.
I sustain the chair's ruling.
Yes. Mr. Osfather?
I vote yes to sustain the chair.
Mrs. Dillon? Mrs. Akin? Yes.
I sustain the chair.
Mr. Brock?
Against.
Mr. Barber?
No.
Mr. Gill?
No.
Mr. Lawton?
No.
Monsieur Fortin?
Oui. Okay. Challenge failed. Mr. Lawton, you still have the floor?
Order.
Go ahead, Mr. Housefather.
He moved a motion.
Correct,
He lost
correct,
the floor.
correct. Thank you. All right, so we're on to Ms. Anstey then. Yes, Mr. Brock.
Seeking unanimous consent that the committee now proceed to the consideration of Bill C-14, the Bail and Sentencing Reform Act.
That's not a point of order, Mr. Brock.
I'm asking for
okay.
unanimous consent, Chair.
Well, I've heard noise on the other side. I don't think you have.
I don't know. We're in support. Are the Liberals in support?
We do not have unanimous consent, Mr. Brock.
I haven't heard anything from the Liberal
I'm
side.
the chair, and I've decided.
I
Mr.
challenge
Brock,
you because I've heard nothing
you're
from the
challenging-
Liberal members.
What are you challenging my hearing?
Yes, I am. I've heard nothing from Ms. Latanzio, Mr. Housefather, Ms. Dillon, and Ms. Akan, who is subbing for Mr. Chang.
Well, okay,
I've heard nothing.
thank you. You've now listed the members. I heard there was no unanimous consent. We are moving on. Ms. Anstey, you have the floor.
Point of order.
Yes, Mr. Barber.
Mr. Chair, I'd like to move a dilatory motion. I'm well within my right. I'm a sitting member that the committee now proceed
You can't do that
to
on
the
a point
consideration
of
of Bill C-14, the Sentencing
point of
Reform
order,
Act.
Mr. Barber. Ms.
I'd like to
Anstey,
seek unanimous
Ms.
consent to
Anstey,
study bail,
Ms.
please.
Anstey, you have the floor.
Point of order, Chair.
Yes. Well, you've got the floor, actually.
I seek unanimous consent for us to move forward on the Bill C-14. That's on the hearts and minds
Ms.
of
Anstey, I'm
Canadians.
sorry to interrupt you, but you're not a member, so you can't move that motion. You can
Point of
speak.
She's
order.
seeking unanimous consent, Chair.
You can speak to it. She
Point
can't.
of order, Mr. Chair.
Where's this one coming from?
Point of order, Mr. Chair.
Mr. Mantle, yes.
Thank you, Mr. Chair. I think if you will seek it and you listen for the voice vote of the committee members, you will see
Mr.
we have
Mantle,
unanimous
I can
consent to
take
move
these
to Bill
motions
C.
from people
Can
who
I
are
finish?
regular members of the committee. You're
Mr.
allowed
Chair,
to
I'd
sit
like
at the
to finish
table
my
and
point of order.
participate. I understand, but you're trying to introduce a motion.
I am not, Mr. Chair. I'm seeking unanimous consent. It is not a motion.
Which you cannot do. You're allowed to participate and make submissions on what we're talking about. Only the regular
I am
members
allowed to
can
make
do what
point
you're
of
trying
order.
to do.
And I seek unanimous consent. If
Mr.
you're,
Mantle, okay, the request is denied. It's out of order. Okay, Ms. Anstey, you do
I
have
challenge
the
your
floor.
decision, Mr. Chair.
Point of order.
Pardon me?
I challenge your decision, Mr.
You
Chair.
can't do that either.
I challenge your decision then.
Okay, that's your right.
I'd like you to put your decision on the record, Mr. Chair.
Just to be clear, what the Conservatives have done is Mr. Mantle has tried to seek unanimous consent, which he is not allowed to do because
Yes,
he
he
is
is.
on a point of order, which he's not allowed to do, even if he was a regular member, which I have
Yes, you
denied.
are.
Mr. Lawton is now challenging that decision, so I guess we'll take a vote on that.
Mr. Chair, point of order.
Yes, sure.
I just would like clarity.
Dilatory
So
vote.
no. I
Yes.
would like clarity
on the same
on
point.
what is being challenged. Is the challenge that a member should be allowed to move a motion on a point of order? Is the challenge on a member of somebody who is not a member of the committee who is present when all the regular members are present? is allowed to move a motion, what is the challenge on? Or is it on both of those? Do the Conservatives believe that in committees going forward, motions should be moved on points of order and non-members of the committee should be allowed to move motions when members are present? What is the Conservatives' challenge?
Perhaps you could clarify, Mr. Lawton, yeah?
Yes, thank you for Mr. Housefather's question. So what we are seeking has been unanimous consent, which any motion could raise at any time. Committees have, as this committee has moved informally where there is consent, we are allowing the Liberals the opportunity to advance their own bail legislation. That's what we're asking.
What he was trying to move, Mr. Housefather's question and the issue at hand is the procedural point.
Yes.
So my question is to you, as Mr. Housefather clarified, what is it you are challenging? What decision are you challenging?
We are challenging we are challenging the Liberals' rejection of unanimous consent and your refusal to hear that.
Okay, all right, we have clarification. Anyway, go ahead.
Mrs. Akin? So that the charge will be sustained. Oh, sorry. Sorry. Mrs. Latencio?
Yes on sustaining the chair.
Mr. Osfather?
Yes. Sustaining the chair.
Mrs. Dillon?
I sustain the chair.
Mrs. Aiken?
Sustain the chair.
Mr. Brock?
Absolutely against sustaining the chair.
Mr. Barber?
No, I disagree with the chair.
Mr. Gill?
Oh, disagree.
Mr. Lawton?
No.
Monsieur Fortin?
Oui.
Okay, ruling upheld, challenge denied. All right, Ms. Ansey, you still have the floor.
Mr. Chair, point of order, Mr. Chair. Point of order, Mr. Chair.
Sir, Mr. Gill.
So, Mr. Chair, we heard the argument, but I ask unanimous consent that the committee now proceed to the consideration of Bill C-14, the bail and sentencing
Already been
reform
dealt with. Ms. Ansey, you have the floor.
Challenge.
Challenge.
We can do this all day, guys, if you want to have fun.
Challenge, Mr. Chair.
Okay, we do one at a time, Mr. Bauer.
This is
This is what?
a sitting member of the committee.
Thank you.
Yeah.
And that's why I just
He's
listened to
allowed
his
to
point
move
of
a
order.
motion.
I know.
for unanimous consent.
The committee's already dealt with it as recently as about 45 seconds ago. So,
Challenge.
It's such a piece of
Point
work.
of order.
Yes,
and
Mr.
this I
Housefather.
want you and the clerk to discuss, Mr. Chair. At this point, we have established that members are on points of order moving motions. This is not allowed at committees, and it is not a challengeable thing at that point. And I am asking you to stop this ridiculous practice that I've never once seen in my 10 years in the House of Commons. The Conservatives are making a mockery of this committee at this point.
Your refusal and to obstruct us to study your bill.
So what, they suspended? Is that what they did? Okay. Now we can tune in a little bit past the suspension because we're still behind by like 20 minutes. Let me catch it right as it comes in.
clarification, and the committee, only the committee members, in other words, the 4 Conservative members whoever they are at any given point, the 1 member from the bloc, and the 4 Liberals are allowed to move motion or raise points of order. Other people are allowed to sit at the table and make submissions that are relevant to the bill, but beyond that, it's only the regular members who can do that, which hopefully will make things run a little bit.
Thank you, Chair. I have a point of order.
Mr. Brock?
Yes. Ironically, as we sit here 2 hours into this committee hearing, the parliamentary secretary to the Prime Minister, the member for Winnipeg North, is challenging, not looking at you, sir, is challenging the Conservatives sitting in the House as to why we are not swiftly passing C-14. And the reason we're not swiftly passing C-14...
This is debate, Mr.
No,
Brock.
well, sir, I'm getting to my point of order.
Well,
I'm getting to my point of order.
Get to it quickly,
I have to
please.
put some context into the point of order. Therefore, Mr. Chair, I am seeking consent of this committee that to improve public safety in our communities and to protect Canadians from repeat and violent offenders, the committee, A, immediately prioritize the consideration of C-14 and work together to report the bill to the House at the earliest opportunity. B, sit through the winter adjournment to undertake meaningful consultations with victims, community leaders, police services and associations, and other relevant witnesses. And C, pause consideration of Bill C-9 to make room on the agenda for Bill C-14.
This is not a point of order.
That is what I seek unanimous consent.
This is not a point of order.
Mr. Brock, that's actually not a dilatory motion, and you can't move a motion on a point of order. So,
I was asking for unanimous consent, Chair. I wasn't asking that you vote a votable motion.
well, I've heard
And
no.
clearly, the interruptions by Ms. Latanzio
Well,
and Mr. Housefather
you don't have unanimous consent.
would clearly trigger. They are not interested
You don't
in the
have
swift
unanimous
passage
consent,
of Bill
Mr. Brock.
C-14. How ironic.
We don't.
Hypocrites.
we
Don't
do-
make
we
no
don't-
assumptions.
Okay. Here we go again. Mr. Brock, we went through this the other night. I was quite clear, and you agreed with me at the time. We are not going to be using that language at this committee.
They can't have it both ways, Chair.
Okay, but we're not going to refer to other members of Parliament with that type of language, because if you do, you will not be allowed to speak again. Full stop. Ms. Ansey, you have the floor.
Point of order.
Who said that?
I did,
Mr.
Chair.
Lawton, okay.
So, changing course here and underscoring what it is we're trying to do here, I have an article that I would like to seek unanimous consent to table. Man facing first-degree murder in partner's killing
it's
had
not a point of
allegedly
order.
threatened her before.
It's not a point of order,
There are
Mr.
three
Lawton.
Quebec members
It is
of
not
that
a
committee
point of
that
order,
should be very
Mr.
interested in people
Lawton.
getting
I've
murdered
ruled,
by people
Ms.
out on
Ansey, you
bail.
have the floor.
Thank you, Mr. Chair.
Finally.
Thank you. And I appreciate the opportunity to come to this committee today and to address the committee specifically around Bill C-9, the sub-amendment that has been brought forward. And please don't misinterpret my passion on this issue as being disrespectful, as I also recognize my colleague, Mr. Brock, is also passionate about this issue. And as a person of faith myself, this is something that is extremely important to me. Faith played an important part of my life, and something that I am very passionate about preserving and protecting in Canada. Now, as a parliamentarian for a riding in Newfoundland and Labrador, I have the immense privilege of representing people of many different faiths, traditions, and worldviews. Our province has a long history of religious diversity, from Christian denominations, but now to growing Muslim, Hindu, Sikh, and Buddhist communities. So my role as a parliamentarian is to ensure that their rights are respected and safeguard the freedoms that allow them to live and express their beliefs openly. And to begin, Mr. Chair, I'd like to just point out that the work of this committee does seem to be misguided and misdirected based on what I hear from the people in my riding, and clearly seen today in several interventions.
Okay, thank you. Yeah, if people in the room could keep their voices, well, quiet, preferably, or to a low tone so we can hear the speaker. Thank you.
Thank you, Mr. Chair. I appreciate that. All voices are important and all perspectives are important, and this is extremely important legislation, so I sincerely appreciate that. And so it's become apparent and obvious that the priorities of Canadians are not being put at the forefront of these discussions today, as we've just seen. And so studying Bill C-9 is letting this committee study something that is misguided and misdirected. It's a bill that is divisive, unnecessary, at a time when we know that Canadians really want legislation that deals with changes in our bail legislation. Now, first and foremost, I'm here today to speak about my concerns as an individual parliamentarian, but also with respect to the immense volume of reach-outs that I have had from constituents on this issue. I have had hundreds of people sign petitions, and it's not just a matter of concern. They are engaged and motivated to want to be an active participant in the pushback on this legislation. Now, one of the things that I think is extremely telling is the part of the country that I come from, which is Newfoundland and Labrador, where they have fundamentally supported and trusted this Liberal government for decades. And they are now deeply concerned about this legislation And I think it's important for the government to reflect on itself and understand that these people who are in my riding, who are nonpartisan, they're community-oriented, they're service-oriented, often focusing and helping people in need, are now alarmed by this piece of legislation. And so I think it's an opportunity for the government to really reflect. Now, I'm not surprised that this is the case, because religious charities in Newfoundland and Labrador play such an important role in rural communities, especially in the province where I live. And I could give you several examples. They run food banks, they run shelters, they run addiction services. In a moment in our history when Canadians are hungry and hurting, our religious institutions are filling that gap and caring for our people, and right now they are under attack. The Premier himself recently acknowledged essential groups like the Salvation Army and acknowledged December 8th to the 14th as Salvation Army Week in Newfoundland and Labrador, again recognizing the important role that religious charities play in our rural communities. So I'm not surprised that these organizations are reaching out to me in the manner that they are reaching out to me, because they play such an important role, and we should be doing everything to protect them. Now, I came into this role as a mom, and I will leave this role still as a mom. Above everything else is my priority and something that I reflect on each and every day. And I think about it consistently in terms of the kind of country that my 4 children will inherit. But also, I teach my children on a regular basis to have difficult conversations, to lean into constructive, respectful conversations, whether they're in the classroom, around kitchen tables, wherever they are interacting, and not to be afraid to voice their opinions, but to respect everyone and treat them with dignity. Thoughtful, respectful disagreement is not a threat to Canadian society. It is the foundation of it. So what message are we sending to the next generation if we are attacking sacred text that is spoken in good faith? This is extremely, extremely concerning to me. And it does not make Canadians safer. It creates a chill. We want to encourage people who have diverse perspectives, that it's safe and okay to voice those perspectives in our Canadian society. Now, this, Mr. Chair, is a bad bill, and the amendment and sub-amendments are required because it's not about protecting rights. It's not about public safety. It's not about community well-being. It's misguided, it's misdirected, and it is completely unnecessary. We can clearly see it's dividing us. But more than us, what we should be concerned about is it's dividing communities. People all the time are talking about divisiveness in this space, and this is something that we should be extremely concerned about. Canadians are begging us to address bail, and instead we are moving in this direction. And Mr. Chair, just as a final thought, it's the eve of Christmas. Christmas is the most celebrated Christian holiday of the year. And this legislation is casting a dark shadow of fear over faith communities right now. This is a time when they should be celebrating their faith, and instead they're reaching out, concerned, fighting that this government would preserve their faith. So thank you, Mr. Chair. I move a motion right now based on my comments and my interventions that we
Colleague?
Okay, Mr. Brock, please, everybody, just keep their voices down. I can control the room, Mr. Brock, and it's easier without help, frankly. Okay, please continue, Ms. Anstey. I didn't hear that.
And so I bring forward a motion right now, Mr. Chair, that the committee shift its focus and study Bill C-14 that deals with the legislation that is on the hearts and minds of Canadians.
Thank you. To clarify for people sitting around the table, Ms. Ansey has been substituted for Mr. Lawton, so she is able to bring such motion. However, having dealt with this motion over and over again, we're not going to consider it. That's my ruling. So we'll move on to Mr. Bauer.
Point of order, Mr. Chair.
You can't make a point of order, Mr. Mantle. You're not a regular member of the committee at this point. Sorry.
Yes, you
Yeah,
can.
we just
Point
made
of
that
order.
ruling a few minutes ago. You might not have been in the room.
Any member can move a point of order.
No, the ruling's already been made, Mr. Barber. That moment has passed. Well, you weren't here, Mr. Jennis. You don't have an opportunity at this point to debate it. Mr. Barber, you have the floor on the sub-amendment.
Thank you.
Excuse me,
now-
Mr. Chair.
That's outside
I'm
watching my
actually,
son,
I'm actually subbed in for a member, so I believe that I do have the ability to.
But I'm also communicating with my
move a point of
constituents
order?
about what's happening. Absolutely. I hope you're communicating with your constituents as well about this. Yeah. People who have their rights
Clerk
taken
has no
away.
record of that.
It's funny.
Mr. Barber, you have the floor.
Sorry,
I'm a
Mr.
member
Chair.
of
Could you
this
double check
committee,
that, please, Mr. Chair?
And I find out
You
more.
just did. Mr. Barber, please.
And I find more about what's going on with this bill from the media than I do from this room. And it appears now that at least twice the Attorney General has U-turned on the block amendment that passed the other day that is the subject of the sub-amendment. Yesterday, just before question period, I learned that the Attorney General now believes that he ought to go out there and consult with communities and consult with religious leaders with respect to the block sub-amendment that just passed to repeal the defense of religious expression. And so, in that spirit, if the Attorney General wants to consult, he should have consulted before the block amendment, before the Liberals adopted this and repealed the religious defense, then why not suspend and allow the Attorney General to perhaps change his mind again, which by my count would be a third U-turn on this bill. And that is why I'm well within my right to seek unanimous consent that this committee now proceed to the consideration of Bill C-14, the Bail and Sentencing Reform Act. May I please have your consent to study bail, to study sentencing, and allow you guys to reconsider again as to whether you wish to repeal the religious defense.
Sounds very reasonable.
Can we please have, may I please have unanimous consent?
Do we have unanimous consent? No. Okay. Mr. Barber, move on. Are you finished? Mr.
I
Bailey,
cede the floor.
Mr. Bailey, you have the floor.
Thank you, Chair. The Liberals in the Bloc.
Sorry, go ahead.
The Liberals in the Bloc Quebecois have made a deal to eliminate criminal code, safeguards for freedom of expression and religious freedoms in exchange for the Bloc supporting Bill C-9. They are removing Section 319.3b and 319.3.1b, which state people cannot be prosecuted for expressing, in good faith, an argument or opinion on a religious subject or based on belief in a religious text. The Bloc has long pushed for the ability to persecute people for religious expression. It unsuccessfully attempted to make these changes in the previous Parliament, known as Bill C-367. The Bloc often cites the case of the Montreal Shakawi, who in 2023 used a prayer to call for the extermination of Jews. Persecutors denied to charge him. There is no evidence he was not charged because of the religious defense protection. What Shakawi said is really illegal. There is no defense for advocating genocide under Section 318 or public incitement under Section 319.1. The defense only exists for the willful promotion of hatred and anti-Semitism charges. The refusal to charge Shakawi was yet
I'm gonna
another
interrupt you, Mr.
example of
Bailey.
authorities taking
Mr. Bailey,
enforcement.
sorry, just bear with me. The room's getting a little loud again, please. Mr. Bailey has the floor.
I'll repeat that. The refusal to charge Chikawi was yet another example of authorities failing to enforce existing law. The Supreme Court has recognized the religious defense as necessary to keep Canada's hate speech laws constitutional because of how crucial freedom of expression and freedom of religion are. The Justice Chair, Mark Miller, said in committee on October the 30th that there was clear hatred in some books of the Bible, the Torah, singling out Leviticus, Deuteronomy, and Romans. I quote, "Clearly, there are situations in these texts where these statements are hateful," Miller said. "They should not be used to invoke or be a defense." He was clear. Prosecutors should be able to press charges. Numerous witnesses told the Justice Committee that the religious text defense is narrow and does not offer blanket immunity, as the Liberals are suggesting. People of faith could be imprisoned for up to 2 years for expressing deeply held religious convictions that the government finds offensive.
Okay,
I can speak louder.
Mr. Bailey.
Yes, I can barely hear myself.
Okay, well, the room is getting a little. The room is getting a little.
Well, put it in.
Okay.
Stop talking.
Okay, Mr. Bailey, we don't need that kind of tone. Mr. Can, we don't need.
Okay, wait a sec. He's got the floor and you don't.
Okay, all right.
Okay,
we're suspended.
Let him speak and let him.
Guys, just.
Wow. So that's where they're suspended. It looks like they are still suspended, or did they come back? Okay, they just came back, so this is live now. Now we're up. Now we're caught up.
I'm really glad to see that Ms. Latanzio is starting to understand the importance of C-14 in her remarks. My constituents are looking to this committee to study that bill. I'm getting a lot of email about it, and they are looking for us not just to send it back to the House, but they're actually looking to hear the perspectives of other Canadians on this. But colleagues, I want to speak today in favor of MP Brock's sub-amendments and MP Lawton's amendment that restores protection for freedom of speech and religion to C-9 after the Bloc and Liberal members of the committee passed an amendment to remove the defense for good faith religious speech from it. I think it was 2 days ago now. All of us around this table know that this defense has never protected the kind of speech that people sometimes imagine that it does. It's never shielded those who deliberately promote hatred. It's never shielded those who promote violence. And it's never actually been a loophole for extremism. The reason that it's existed, as I explained in my intervention a couple of days ago, is to protect sincere expressions of belief by people who are acting in good faith, even when others strongly disagree with them. And yet, the moment that the Liberal Bloc amendment passed, we actually started to see exactly what many of us warned about. My honourable colleague from Niagara West just spoke about unintended consequences, and I'd actually like to provide an example of that. Because on my own social media, in the short time since this amendment passed, a community member who does, I will acknowledge, comment frequently, wrote, "Happily it passed," and I'm quoting, "happily it passed, and people like Charlie Kirk in Canada won't be able to hide hate speech behind religious freedom." Now, every member of this committee knows that the amendment will not enable any such thing. It is not going to touch the kind of speech that this individual was talking about. But what the comment does reveal is something very important to our deliberations here. And it reveals a sentiment that I hope that this committee will find very troubling, because it is an example of just how quickly and in what manner this amendment will be weaponized. In my remarks the last time we sat, I warned that this amendment would be interpreted by members of our communities as having significance by those who want to silence people whose views they don't approve of. And this comment, which came in such a short period of time, shows how easily people will assume that the removal of the defense gives them license to silence views that they dislike. It demonstrates how eager some Canadians are in this moment and time of tension and division to believe that the criminal code should be used not only to stop hate, but to stop conversations that they find uncomfortable. This is exactly why this defense existed in the first place. It was never about protecting bad actors, and what it was about was protecting the space for good faith disagreement in a diverse and pluralistic country. It acknowledged that Canadians hold deeply different convictions on questions of faith, ethics, and morality, and this is reflected in some of the case law. Some of these differences that we have around these topics do run directly into each other. That is the reality of pluralism. The good faith religious defense ensured that people could express their beliefs without fear that someone would accuse them of hate simply because they hold a traditional or unpopular view. So removing the defense doesn't stop hate. Hate is already prohibited. Removing the defense, though, does send a very different signal, and it suggests that the state is narrowing the space for sincere disagreement. It invites people to believe that if they find a belief offensive or outdated, it might now be criminal. And it encourages exactly the kind of misinterpretation that I saw within hours of the vote to pass that amendment, where someone confidently declared that this amendment allows us to target each other. So if the Liberals and the Bloc continue to support the removal of the good faith defense from C-9 and don't support our amendments to protect freedom of speech and freedom of religion, Canadians will be able to conclude that will conclude that it is the intention of these parties to encourage the kind of misinterpretation that we are already seeing online, and that they support the weaponization of C-9 against people of good faith with views that are distasteful to them. Tensions are high in our society, Chair. People are frightened by what they see online. They are exhausted by polarization and desperate to make some of the dialogue out there stop. I understand that impulse. I think every one of us in this committee does. But of all the times in our history, this is an especially irresponsible moment to remove this defense. The criminal code is literally the bluntest instrument we have. It allows the state to restrict people's freedom, fundamental freedom of movement and of liberty. It cannot and must not be used to manage discomfort. It cannot and must not be used to stifle legitimate conversations. When emotions are running this hot, Chair, Parliament needs to be especially careful, because in moments like this, people do not draw fine distinctions between hateful expression, which is already illegal, and beliefs that they find personally objectionable. They see disagreement and they assume danger. They see traditional religious statements and they assume hostility. And now, without the defense that has long reassured faith communities, they may also assume that these sentiments are criminal. That's why the committee's amendment this week was so irresponsible, and why Mr. Brock's sub-amendment and Mr. Lawton's amendment are so important. This committee's misguided amendment did not strengthen protection for vulnerable communities. Instead, these protections are already strong. Instead, it weakened the safeguards that preserve space for peaceful disagreement, and it increased the likelihood that ordinary Canadians will misunderstand our intentions and misunderstand the law and try to use it to silence those that they disagree with. The example that I gave at the beginning of my remarks today are not an outlier. They're a preview. It is the very outcome that many of us warned about. It shows how quickly this disturbing Liberal Bloc amendment will be deployed, not against hate, but against dissent, against neighbours, against community members. And once accusations of criminal hate speech begin to be thrown around, in some cases lightly, trust will break down even further. People will retreat further into their corners. Dialogue will become harder, and the very fabric of our pluralism may begin to fray. Our responsibility as legislators is not only to protect Canadians from hate, but it is also to protect the conditions that allow Canadians to live together despite profound differences. That includes protecting the space for those who express their belief in good faith, whether we agree with them or not. The good faith religious defense was one of the mechanisms that allowed us to maintain the balance. Its removal creates uncertainty where clarity is needed. It invites misuse at a time when restraint is essential. I urge this committee to reflect carefully on what is happening in this room this week and on what we are already seeing out there on social media. When the public misunderstands a legal change within hours of its passage, that is a sign that Parliament is doing the wrong thing. The person who made this comment on my social media is not an unintelligent person. It is not an unkind person. It is simply a person who saw what this committee did and believed that circumstances had changed sufficiently to make them be able to go after people whose views they find distasteful. When people believe that the criminal code can now be used to silence views they dislike, that is a sign that we have created expectations that law cannot meet. And when those expectations encourage people to weaponize accusations of hate, that is a sign that we are moving in a dangerous direction. We must recommit ourselves to a balanced approach. We must protect Canadians from true hatred, and we must also protect the space for good faith expression, including religious expression that we find offensive or distasteful, in a country that depends on respectful disagreement to function. Removing this defense, Mr. Chair, does not advance justice. It undermines the very conditions that allow justice, pluralism, and civil dialogue to survive. This committee's unwillingness to put C-9 aside, despite its obvious shortcomings, also stops this committee from dealing with the important issue of Liberal bail. As the Liberals sit here trying to restrict the freedom of Canadians, they are letting violent criminals out on bail to do more damage in our communities. Their colleague, the parliamentary secretary to the leader of the government in the House of Commons, is also sitting in the House verbally attacking my Conservative colleagues, and I quote, to relax our stubbornness on not moving swiftly to pass C-14. I think he must have meant the Liberals, Chair, because the people who have been following these proceedings and the proceedings of the House at home can see, we can't get this committee to move to study C-14. I implore this committee to move on, to do the work that is necessary to make all Canadians safe, and accordingly, I move again. In light of the remarks that I've just made, and in light of the remarks of the parliamentary secretary to the leader of the government in the House of Commons, made in the House of Commons within the last 90 minutes, that this committee now proceed to the consideration and study of Bill C-14, the Bail and Sentencing Reform Act. Thank you, Mr. Chair.
Thank you, Ms. Corns. Thank you. To clarify, are you seeking unanimous consent? Is that what you're doing?
Yes. Pardon?
Moving.
Yes, I'm actually making a motion, as I believe I'm entitled to do, and it's a dilatory motion, and I believe it must be put to a vote.
You're allowed to bring the motion. We've
I am
seen a
bringing
bit
a
of
motion.
both throughout this morning. I just wanted to make sure which one we were on.
Yeah, no, I'm bringing a motion, and I'd like a recorded vote, Mr. Chair.
Okay, well, I'm ruling the motion. We've already decided that motion several times today, so we'll move on. Who has this floor next? Mr. Mantle.
I'm like 5th or 6th after this. Are you going to be ready to talk?
Thank you, Mr. Chair. I'm free to proceed. And I believe to confirm I'm subbed in for
Mr.
MP Gill.
Correct.
Is that correct? Thank you, Mr. Chair. Thank you again for the opportunity to speak on this issue. In particular, to speak on Mr. Brock's sub-amendment to Mr. Lawton's amendment, which are critical to bringing back religious freedom and the freedom to express your sincerely held religious beliefs, to read from sacred texts, whether that be the Bible, the Torah, or any other texts, which my colleagues in the Liberal Party seem to believe are hateful. And we know they believe that because one of the ministers.
Yeah, Mr. Housefather has
I'm
a
so
point of
sorry,
order.
but to make the claim that we believe that a religious text is hateful goes beyond
That's
debate.
not a point of order.
I would ask that would be withdrawn. That is very unfair.
I'm
Point of
inclined to
order?
agree with Mr. Housefather Mantle. We're
Point of
all
order?
entitled to express our views on the pros and cons of it, the sub-amendment or the amendment or the bill itself. But suggesting that anybody in here and challenging their faith in that way, with all due respect, sir, is completely over the line. I would ask that you refrain from doing that going forward.
On the same point of order?
Mr. Lawton.
Just on the same point of order, a quote from former Justice Committee Chair Mark Miller, October 31st. There is, quote, clear hatred, unquote, in books of the Bible and Torah.
This is debate.
No, I'm affirming that what he said
This
is entirely
debate,
valid.
Mr. Lawton. Thank you very much.
Your predecessor literally
Mr.
said
Mantle,
holy
please
books are
continue.
hateful.
Mr. Lawton, you're done. Mr. Mantle, please continue.
Man, he's a piece of work.
Thank
This
you, Mr. Chair, and I take your comment seriously, and I don't mean to suggest certain members or all members have that view, but I will read into the record the views of one member of the Liberal government who made these comments on the record, so I don't believe that could be impugned in any way. I mean, these are his words. They're not mine. Is that permitted? Mr. Chair, may I read his words into the record? Mr.
I
Mark
don't know
Miller's?
which member you're talking
Mr.
about,
Mark
which
Miller's.
words those are, so let's deal with it as it comes.
Okay, then I will read Mr. Mark Miller's words into the record, and if you think that that's inappropriate, you can tell me at that time. But he said in committee on October 30th, quote, clearly there are situations in these texts where these statements are hateful. And further, Mr. Miller said, quote, they should not be used to invoke or be a defense. And he said, quote, that prosecutors should have the ability to press charges. So my view on that is that that's Mr. Mark Miller's opinion, that these texts that I just referenced clearly are hateful, and I think that's fair to say that. Those are his words, not mine, Mr. Chair. And that goes to the point of why Mr. Brock's sub-amendment to Mr. Lawton's amendment is important to be passed by this committee, because we have a Liberal minister who made these comments, and in fact, he was promoted after those comments were made. So I'm not sure what signal Canadians should take from that, from the Prime Minister's decision and his judgment to move someone who holds those views into a position of authority in the government. And not just any position, but Minister of Culture and Heritage. I think our religious beliefs and faith and our ability to express them are critical and
Sorry, I'm going to interrupt you, Mr. Mantle. The room's getting a little loud. Mr. Mantle has the floor. I think we need to show him some respect on both sides, please. And at the back. I know there's food in the room, but please keep your voices down, or preferably just don't talk at all.
Thank you, Mr. Chair, for that reminder, and it's well noted. Just to move back a step to what I was saying, I was commenting that I was asking a rhetorical question of what type of signal it sends to Canadians when the Prime Minister, in his judgment, decides to promote a minister who holds that view and who has said it publicly. In my view, that calls into question the Prime Minister's judgment. That calls into question his commitment to the free expression and the free religion, that the ability to express our religious views that should be protected by the government. Recalling, of course, that the Charter is meant to protect Canadians from the overreach of government. That's part of its purpose, to curtail the ability of government to circumscribe Canadians' fundamental freedoms. And I'll remind members that freedom of conscience and religion is in a section of the Charter that refers to them not only as freedoms, but fundamental freedoms. And there has not been, in my view, enough scholarship and discussion on that, because when we interpret a constitutional text or a legal text, we have to give effect to the words that are there. That's a general principle of interpretation. I'm sure my justice colleagues would agree with that maxim. And so when the Charter says that these are fundamental freedoms, I think we have to ask ourselves why that is and what the drafters of that section meant to convey to Canadians about these freedoms. I want to talk about three things, Mr. Chair, in my remarks. First, I want to talk about a laudable goal, but I also want to talk about a faulty premise that the Liberals have about a laudable goal, and then finally, misplaced priorities. So a laudable goal, faulty premise, unfortunately, and misplaced priorities. The laudable goal, of course, is combating hate and acts that promote hate or propagate it or normalize it. And I think I share the goal that Liberal members do and Conservative members do and Bloc members do, that we want to have a society that does not promote that, tolerate that, accept that. And that is a laudable goal. But unfortunately, that laudable goal will not be achieved by Bill C-9. And that's the faulty premise, Mr. Chair. The faulty premise is that the government, the Liberals, with their co-conspirators, the Bloc, believe that taking away people's religious freedoms will somehow stop the promotion of hate in Canada. Now, just on its face, on a common sense prima facie basis, that doesn't follow. But it's worse than that, because not only will this not achieve the goal that they have set out for themselves, but in fact we are seeing that it might actually be weaponized against those who hold a different view than those who are in power. And I think that was on display with Mr. Miller's comment, that it wasn't for Mr. Miller, it wasn't about, or might not have been about, I won't impugn his intention, I'll just read his words, but it might not have been about defense, but rather using it as a sword. And oftentimes in legal discussion, we talk about whether laws can be used as a sword or a shield. And this defense was, of course, meant to be a shield to an allegation of hate speech. But in fact, we're seeing it potentially be used as a sword. So that undermines this laudable goal and leads me to believe that this Bill C-9 was brought forward on a very faulty premise. It's also a faulty premise, Mr. Chair, because we know that many of the things that members have complained about or that members of our community have raised with us are real. I, for the last 8 years, just over 8 years, worked right downtown. My office was at Bay and King, Mr. Chair. And after October 7th, I played witness to marches right down the center of Toronto that I have never witnessed in my life. And, there are often protests downtown, and, frankly, none of us who used to work in ivory towers paid much attention to them. But this was different. Many times I and colleagues of mine out of the BMO Tower, First Canadian Place, went down to the street to see what this was about. And frankly, Mr. Chair, I was horrified to see what members of those protests, if you want to call them that, were saying, what clearly their views were based on what they were yelling, what they were arguing with people on the street. They were, I'm not a prosecutor, it's not my area of practice, so I leave that, whether it rose to the criminal code definition of hate speech. But as a layperson, it certainly seemed pretty hateful to me. And then I saw, over the next months, that progress to not only marching in downtown Toronto, but marching into northern Toronto, up Bathurst Street, into Jewish neighborhoods. Now, again, I'm not an expert on protests, but you have to ask yourself, why do people want to go and protest in an area of our city that is heavily populated by one community, and one community only? So it doesn't take an expert to know that that section of the city was picked because of the members of the Jewish community that live there. And so I, again, as a layperson, I think that's pretty hateful. But this goes to my faulty premise, Mr. Chair, because those actions of those people in those protests may have been already criminal. And I'll just mention a few of the provisions of the code that I think may have been at issue. Of course, leave it to the Crown and the police to make the ultimate determination. For example, in the code, section 63 for unlawful assembly. Section 175, causing a disturbance. Section 176, obstructing or disturbing religious worship or meetings. Section 264, criminal harassment. Section 264.1, uttering threats. Certainly heard threats at those marches. Sections 298 to 317, defamatory libel. Section 423, intimidation. And Section 430, mischief. Now, there may be other sections, Mr. Chair. That's just what I was able to glean in reading through the criminal code. And I would submit to members of the committee and to those who support Bill C-9 that what they are trying to achieve is already achievable in the criminal code. So the question then is, well, why are the police and the Crown prosecutors not going forward with this? And I think there's at least one reason that comes to mind. And I would suggest that it's a lack of political support and political will. And that's both at the municipal level of government with the City of Toronto and also at the federal level of government with the Liberal government. And I don't think it's unreasonable for police and prosecutors to want to have their political leaders stand up for them if they are going to enforce these provisions of the criminal code. But they don't. They don't, because they going back to Mr. Miller's comments, they hear comments from the government and from senior ministers about how they should understand what's happening in Toronto and other places across the country. And they don't see support for them to enforce these laws. So while I would encourage and in fact demand that the police enforce these laws that exist to protect our religious liberties and those of our Jewish community in this particular example, but of course to do that for all religious communities in this country. And I think all parliamentarians should expect the police to do that. But I understand why they may hesitate, because they do not have the support of the government. They do not have the support of the Prime Minister. They do not have the support of the Justice Minister. And they certainly don't have the support of the new Minister of Culture and Heritage. So, Mr. Chair, laudable goal, faulty premise to achieving it, unfortunately. The last thing I wanted to talk about in my submissions, Mr. Chair, was misplaced priorities. And that has been on full display here at the committee. Now, we have all heard the stories of violent offenders out on bail or being released on bail who then commit more violent offenses. And they've been across Canada. And I think, for example, one example, poignant, the case of Bailey McCourt. And as we've learned, the accused in that case, Mr. Plover, James Plover, was supposed to have gone through a consideration of various factors prior to being released. And of course, in that story, we know that Mr. Plover was released and committed a horrible murder of his former wife, I believe, his estranged wife, I should say. And that has shooken Canadians. And rightly so, it has shooken Canadians, because Mr. Plover should never have been released. And I have a report on that. And Mr. Chair, maybe I could, I think this is important, especially for perhaps Mr. Chang, who this is part of in his province of British Columbia. I wonder if I could just have unanimous consent to table this report here with the committee as evidence, especially for Mr. Chang and other members of from British Columbia. Would I have unanimous consent for that?
Can you do that? Do we have unanimous consent? No, we don't have unanimous consent.
Sorry, Mr. Chair, just to clarify, there's no unanimous consent?
There is no unanimous consent.
Yeah, I mean,
Point of order.
Yes, Mr. Lawton.
Just with respect to my colleague, I know when we were suspended earlier, there were some discussions amongst parties, and Conservatives have always been willing to try to find a way forward on this. I just wanted to ask, given that the Minister of Justice is in Ottawa today, that the committee invite him to appear immediately in relation to Bill C-14.
Not a point of order.
I'm seeking unanimous consent, Chair, for the Minister to appear immediately on C-14.
I've heard it, no. Okay.
Well, they haven't heard what I'm asking unanimous consent for. They don't know that they're against it yet. unless they're against all requests to cooperate across
understood what
party
you're
lines.
asking for, and I heard a no. So we're going
But
back to Mr.
I hadn't
Mantle.
finished the request. But the Liberals don't want the minister to be able to testify?
There wasn't a point of order anyway.
That's strange.
Mr. Mantle, continue, please.
Thank you, Mr. Chair. And just to recap my understanding of my request, so there's no unanimous consent to table information
Correct.
about the case of Bailey McCourt.
Correct.
Okay, thank you. That's unfortunate. I don't know why members of the Liberal Party would not want more information about a very serious case, but you know, Canadians can make their own judgments on what that says about the priorities of the Liberal members of the Justice Committee and what they want to talk about. I mean, they can say it's nonsense, they can heckle nonsense, but I leave it to Canadians to decide for themselves what they think those priorities are.
I'm sure there's a lot of Canadians asking those questions today, Mr. Mantle. So rather than, you know, ascribing motives and things to other people, let's stick to the core discussion here.
Mr. Chair, I completely agree with you, and on the record, I did not suggest their motives. I said others, you know, the public can make their own determinations on that. But going back to my discussion of misplaced priorities, Mr. Chair, they are misplaced. The members of this committee, I think, and I will make a statement here, I think the members of the Liberal Party on this committee have misplaced priorities by not wanting to discuss issues of bail and sentencing reform. We have asked numerous times to go to consideration of Bill C-14, the Bail and Sentencing Reform Act, which the government says is an important piece of their criminal justice agenda. But I have to wonder if it really is when they refuse to move to consider it. And it's not like they're suggesting there's something more important that should be considered. They're suggesting instead we should be arguing about the circumscription of religious expression and freedom in this country. And so, to me, that's very clearly a misplaced priority on the part of the government. To not want to talk about bail and sentencing reform, not want to talk about how we fix a broken system, which has been broken, frankly, by the actions of the Liberal government.
Sorry, Mr. Mantle, we have a point of order. Mr. Housefather.
Relevance to the amendment that is on the table, Mr. Chair?
You don't
I've given 11 minutes of leeway.
We're not going to have the
before
back and forth across the table, please, gentlemen. You made your point of order. Mr. Mantle, if you can explain how this is relevant to the sub-amendment.
Absolutely, Mr. Chair. I think I laid out quite clearly how I think this is relevant to this discussion. There's a laudable goal in C-9, which was undermined by the Liberals' decision to remove religious defense, which then Mr. Lawton sought to amend to add in clarification on that, and then Mr. Brock's amendment sought to further clarify and expand the scope of that, and that's the laudable goal. The faulty premise, of course, of C-9, and then their misplaced priorities and not wanting to deal with Mr. Lawton's amendment and Mr. Brock's sub-amendment. So I would suggest that's directly relevant. If you can certainly, I mean, we can get to a vote after members have had their ability to express their opinions on that. You know, I mean, they can laugh all they want, and if their laugh is suggesting that this is not, that religious freedoms are not an important
Nobody's
discussion.
laughing at that, Mr. Mantle. Look, I mean, look, there's procedural shenanigans going on around the table. We all know that, and anybody watching knows that. Telling people that they're laughing over some substantive issue is not accurate. Let's carry on, please.
Like you can't make substantive opinion-oriented comments.
Carry on, Mr. Mantle.
I am.
Do I?
And I can't.
I still have the floor, Mr. Chair,
You're
so
the
I'll continue. You know, I respect you as chair, and I'm still new in this place and learning, you know, the role of the chair, so I accept that. But I would suggest that it's not the chair's role to police the content of speech in the committee. Obviously, relevance is important. I've explained how I think it's relevant. You know, if you disagree, you're free to do that as the chair and use what power you have, but I suggest it's relevant, and I'm going to continue on my points. Going back to my third point of my remarks today, Mr. Chair, which is misplaced priorities. I am suggesting that the Liberal government has misplaced priorities by not wanting to talk about bail and sentencing reform, which they have said is an important issue, frankly, only because we have been raising it and Canadians have been raising it in response to these outrageous acts of violent offenders being let out on bail and committing horrendous violence again. And instead of wanting to talk about that, we are stuck on the Liberals' Bill C-9 attempt to curtail and suppress religious expression, sincerely held religious beliefs, including those from religious texts. And I think that's a serious misplacing of priorities. So, Mr. Chair, in summary, I think that Bill C-9 had a laudable goal. Unfortunately, it was brought forward on a faulty premise. And in fact, it will not achieve the goal that the government says they hope to achieve. And instead, that they are moving to misplace their priorities by talking about this issue rather than bail and sentencing reform. And so, Mr. Chair, given that misplaced priority, I would like to move the following motion. Given that the Minister of Justice is in Ottawa today, the committee invite him to appear immediately in relation to Bill C-14 with respect to bail and sentencing, followed immediately by a clause-by-clause consideration of Bill C-14, followed by a clause-by-clause consideration of Bill C-9. And if they are serious about what they say, the Liberal members will support that and bring the minister here today.
All right. Yeah, the motion's out of order, Mr. Mantle. Mr. Brock, yeah.
How is it out of order?
Asking for unanimous consent for the following. Given that the Minister of Justice is in Ottawa today, the committee invite him to appear immediately in relation to Bill C-14.
You cannot do this on a point of order,
with respect
Mr.
to
Brock.
bail and sentencing, followed immediately by clause consideration
Mr.
of
Brock, we can talk
C-14,
over each other, or you
followed
can
by
respect
clause
the
by
chair
clause on
and
Bill
respect
C-9.
the interpreters.
Point of order,
we can
Mr.
do
Chair.
this all day long.
Point of order, Mr. Chair.
I'm addressing Mr. Brock's point of order. Mr. Mantle, just be patient. That's inappropriate at this time, Mr.
Okay, and I'll
Brock.
be raising it again when I'm recognized.
You're right.
When is that, Clerk?
Point of order, Mr. Chair.
I'm going to suspend for a few minutes. Not
This
because
is
of what's
just directly on my.
I've had a request that we suspend
I want
for
to know,
personal reasons, Mr. Mantle.
For personal reasons? I wonder if he's just doing that so that way they don't have to come back to this. What a joke, man. While we wait, we can tune into the original committee, which we were going to watch in the first place, which was public accounts. But then as soon as I saw this come up, we tuned right into this. So we'll switch back here. If
Which
they
you
do
also mentioned
ever
is
come back
that
from
is there more to
suspension.
be done? I think there's like the systems that have been put in place. I'm very confident that they'll deliver. But until we've actually monitored and actually seen that, we don't know. So at the end of the day, what I continue to do is making sure that we put in place a solid monitoring system. At the end of the day, that can sample a number of contracts post-award to ensure did the system work as intended, and if it does not as intended, then we make adjustments further.
Thank you very much. And after the Auditor General's reports, do you think your departments and your staff need more trainings?
A short answer, please.
So I can say there was extensive training that was taking place before, but since that time we've actually added some additional training that the people need to do in the department.
Thank you. Thank you, Madam Chair.
Thank you.
Yip is a chair?
Okay.
What?
And now for the third round, Mr. Stevenson for 5 minutes.
Thank you. I'll reiterate, and it's our last one before Christmas, and want to wish everybody a Merry Christmas before we're off from today. I also want to say thank you to the witnesses for coming. It is refreshing to hear all of them say that they accept the auditor's reports and findings and the recommendations. We've had many a witness in the previous that did not accept both. I'll start with Ms. O'Gorman with CBSA. Partly in a timing issue, if you could tell me, you talked about you canceled the one contract was canceled. Was that I'm not entirely clear on the timing of it. That was before the Auditor General actually had looking at the contracts and having any recommendations. Is that correct?
That contract was set up to run from October 22nd to October 2022 to March 2023, and we canceled it in December of 2022. So a couple of months in before spending any money. So yes.
Long before the auditor actually even looked at the process there. Now, you also said that you had implemented all the recommendations. Now, again, on timing, was this a lot? This is all after contracts were decided and after or that one was canceled, and so all these implementations were in the last year that you were talking about?
Say 2 years.
Last 2 years?
Yes.
Now, if that's the case, can you tell me why in the process, I guess part of the problem was the documentation is why we don't know for sure, but I don't know if you can tell me why it was canceled and if you'd actually felt that you had internal abilities to deal with it beforehand, why you actually started the contract to start with.
Thank you for that question. The cancellation came as we were looking more closely at how contracts were managed in the agency. And so not to say that the intent behind this, it was benchmarking, looking at the CARM project going forward and how we would manage that. But we just started to take a pause on all of the contracts, understand whether we had an internal capacity, and that hadn't been the practice before. And there was an expertise that could have been brought to bear, but as we looked at the size of our project management team, the expertise they had accrued, we concluded at a high level we didn't need to have that contract in place. But the process and the process of rethinking before we had contracts hadn't started quite as deliberately as it did until the fall of 2022.
Okay. Just one last question, and it may have nothing to do with the auditor's report on this, but the government has said that they're adding additional CBSA officers to this. Can you clarify that that has nothing to do with the management of any of these programs? This is all going to be dealing with people at the borders versus actually anything we've dealt with that would have been in these contracts or would have been dealt with on this side before?
They would not be involved in what we're, but I just want to clarify, they won't necessarily be at the physical border. They may be inland, they may be doing compliance on trade, but they're not related to the subjects of these contracts.
Okay, thank you. How much time do I have there, Chair?
You have 43 seconds. 42.
Oh, not enough there, but I guess I'll go to Mr. Jennings with again to do with the timing. It seems I do appreciate your acknowledgement of the issues and that you've taken these up. But can you tell me just as well on the timing of implementation of things of the recommendations that you've done with these measures in place?
Yep, I'll be glad to. So I talked about an independent function in terms of quality assurance that's independent from the teams that are seeking to procure. So that was established in 2024. What was also established in that same year as a response to this audit is what I said is 100% quality assurance. So does actually depend on the type of procurement. There's a number of questions that get asked and documentation that has to be submitted.
Thank you. I as a CPA, I learned long ago that documentation, if it wasn't there, especially with CRA, you're guilty until you can prove otherwise. So you need to make sure you have the documentation, and that goes back to all the auditing is to make sure that. So I think that's my time. Thank you.
Thank you. And I will just borrow some of Mr. Osborne's time with one question, and this is to Mr. Jennings. How does the BDC ensure impartiality when selecting suppliers and in the awarding of contracts?
That question would be ideally asked of BDC itself. But what I can say, what I know is that ultimately they run their processes fairly and transparently in terms of ensuring that when people bid for service, that when they seek services from companies, that they run competitive processes and select the ones that have the highest merit. But I think that question, honestly, is best asked of BDC.
Thank you, Madam Chair. I'm going to go back to a previous line of questioning from my previous remarks. 5.8 in the Auditor General's report, internal reviews at Crown Corporations. Crown Corporations are not subject to Treasury Board procurement and internal audit policies. They were therefore not included in the Office of the Comptroller General's review. Instead, in February of 2023, the President of Treasury Board requested ministers who are responsible for Crown Corporations to communicate information to the heads of Crown Corporations to encourage them to undertake, in the same spirit, those reviews. The Section 513 of the Auditor General's report, since not all Crown Corporations conducted internal audits or reviews and were not subject to review by the Office of the Procurement Ombud, we encouraged Crown Corporations to examine the recommendations of these various reports and our findings in this report to identify opportunities to strengthen their own policies and procedures. So 3 of the agencies, I was somewhat satisfied that they're looking to put in place similar recommendations that Treasury Board had put in place. And I will say, Mr. Roy, before I ask my question, that I think Canadians who are watching this program should know that your agency does a tremendous job return on investment. I believe it's over 8%. So you are doing an incredibly good job on investing on behalf of pensioners, federal public servants. But I found your response was a little dismissive. The President of Treasury Board encouraged you in the same spirit, to review the recommendations from previous reviews. Your response was, well, we're not subject to their policies, so we didn't. The Auditor General made the same encouragement. So 5 of 10 agencies conducted the review. Yours did not, on the encouragement of the President of Treasury Board. The Auditor General made the same encouragement, and you did so. What's the difference?
I'm correcting what I've said before. Ce que j'ai dit, c'est que
what I said, we're not a mandated Crown Corporation, so we're not necessarily subject to the recommendations. However, PSI has very high standards based on the recommendations made by the Auditor General in order to increase our capacity to deliver the mandate and to improve services. We based ourselves on the recommendations. That being said, the procurement process is very robust and further improved by the recommendations.
If I might add something here, I would like to acknowledge that PSP did conduct an internal audit themselves, and that was, I think, consistent with what the President of the Treasury Board had asked. What we had recommended, and you have pointed exactly to the paragraph in our report, is that there are opportunities to learn from this report and other reports, and we encourage every organization to capitalize on those opportunities. Thank you.
You have 16 seconds.
Oh, I'll carry on to the next.
Okay. For 2.5 minutes.
2.5 minutes, Mr. Lemire. Thank you, Madam Chair. Mr. Hayes, for several years now, the OAG has looked at performance in various sectors, but I have the impression that comes back and back. It's that the IT contracts, every time there's always a significant increase in costs, and these contracts have been underestimated in the past. The modernization of benefit payments, for example, there's a trend here. How can you address this issue as a legislator? What actions can we take? Because when you get right down to it, it's the taxpayer who pays for this, and given the amount of investments that we make in IT. Thank you. I would say the point that the Deputy Minister raised with respect to estimates is important. Obviously, when projects begin, they don't have all of the information required to make a proper estimate. But now the government, and I think, and the Treasury Board is working on this project as well, we're trying to improve the cost estimate process. I would say that with our audits, with the reports that we've presented to Parliament, we've talked about the importance of looking at cost. And here in this report, we talk about the importance of looking at costs before awarding contracts. So I think the key message here is that costs are important for Canadians. We have to look at all of the information possible when we begin a project in order to estimate cost as accurately as possible. But there are some aspects that are worrisome. JC Strategies had only 2 employees, so one of the largest contracts were given to them through PSPC, and there was this Indigenous firm that had only 4 people. How can we ensure that we're not giving huge mandates to companies that are obviously unable of controlling or doing the work that we've contracted them for? Yes, I could say that the recommendations we made are found in other reports with respect to controls.
Any second now. It's showing it's back, so we'll just wait. I don't want to miss a second of this. I also turn it up because I think I had it at 120 or 30 before. There we go.
Mr. Chair, I believe when we suspended, I had moved a motion to request that the Justice Minister appear before committee to do clause-by-clause consideration.
We've already moved on from that.
I would like. I realize you ruled on that, Mr. Chair. What I would like is the reasons for that ruling.
There is no reasons, Mr. Mantle. I made up my mind based on information I have before me.
Thank you. I assume it's arbitrary then.
No, it's well thought out, in fact, Mr. Mantle. But if you want to question my judgment again, feel free to do so. It'll be the last time you speak.
I can't question it without the reasons. What? Feel free to put them on the record.
All right, Mr.
Yes. Thank you, Chair. Some housekeeping matters to address first. I had asked you some questions earlier today, and I found out that there was an email that was shared with our leadership that would seem to indicate resources are now available on today's date until midnight. I would like clarification of that, sir, if you have that information to confirm or deny. Secondly, several colleagues have approached me with issues regarding travel. specifically in relation to whether we are sitting tomorrow. Decisions need to be made, flights need to be booked. So I don't know if you've got an update for us, Chair, with respect to sitting tomorrow. Again, the Conservatives are prepared to do that if resources are available to us. So if you could address that at some point sooner than later, Chair, that would be appreciated. And now that I officially have the floor, perhaps maybe I'll give you the opportunity of addressing that before I move on.
I was going to say, I thought that was official. I haven't seen the email you're referring to. As I explained to you earlier today, I've put in a request for additional resources in the future. I have no further information than I did for you earlier today.
Which future? The distant future, the near-term future?
And as far as travel plans go, I mean, the nature of our job, I probably change my flights 3 times every week. So I will give you the information as soon as we have it, Mr. Brock.
My only concern is, given that the House is expected to rise shortly after QP, there's going to be a number of members utilizing the Ottawa International Airport. Many of us may not be able to book a flight. So the sooner that we know, the better that we can make appropriate arrangements.
Again, it seems you have better information than I do. The
Maybe
House is rising.
Maybe I do.
That's the best thing I've heard you say all day. So.
Maybe I do. Well, I've got a lot left in the tank. Believe me, I've got hours and hours left in the tank. So I appreciate that. So given that I officially have the floor, I am now moving a motion that, given that the Minister of Justice is in Ottawa today, the committee invite him to appear immediately in relation to Bill C-14 with respect to bail and sentencing, followed immediately by clause consideration of C-14, followed by clause on Bill C-9. Recorded vote, please.
The motion is not receivable, Mr. Brock, because we're still in the middle of the discussion on the sub-amendment. So if you have submissions on the sub-amendment, you have the floor.
What authority are you relying upon, Chair?
Yeah, we're dealing with a sub-amendment, which is a motion in itself. It's one motion at a time. It's not receivable at this time.
All right.
Let's seek unanimous consent to the same.
Can I seek unanimous consent at this point for all the reasons I have read out?
You can try.
Okay, and I guess
and we do not have unanimous
secretary. Sorry, the parliamentary
Mr. Brock,
secretary.
these are not
Justice
recorded votes.
No.
You do not. It's not appropriate to identify people who are speaking when the mic is not on.
Well,
you do not have unanimous consent, which I've made very clear.
Thank you.
So if you have submissions on the sub-amendment,
I have some more.
Thank you, Mr. Brock.
Some more submissions to make. Just received notice of a woman from Quebec in Longueuil who was out on bail, arrested again after a black child, aged 10, was scalded with boiling water. Given the significance of this case, given the significance of the Bail and Sentencing Reform Act that is Bill C-14, I'd like to table this article with the committee at this time.
Do we have unanimous consent to table the article?
Mr. Chair, what is the source of this article?
From the Gazette.
Dated when?
Dated.
Is it translated, Mr. Brock, just out of curiosity?
It is not translated. It is only in English.
Okay, so we'd need unanimous consent then to waive the.
Mr. Chair, how is that relevant to the sub-amendment?
Well, it's not translated anyway, so I think we're not going to get anywhere. Yeah.
Thank you.
Thank you.
So we have no unanimous consent?
We do not have unanimous consent because the article, if for no other reason, because the article is only in one official language.
Thank you. Prepared to cede my time at this time.
Thank you. Which takes us to Mr. Gill. Good question. Wait, which Gill? No, I think it was Mr. Gill, who's not here anymore. So it's Mr. Okay, it's our regular Mr. Gill, who's the regular member of this committee. Yeah.
Thank you. Thank you, Chair. I'm grateful to be able to once again speak on Bill C-9, the Combating Hate Act, and specifically to Mr. Brock's sub-amendment. It is an excellent sub-amendment. I believe I can state without controversy that all members of this committee want to take action to combat this rise in hate crimes. We all want to help make our communities a safer place for residents to live, work, and raise a family. We all want to give our law enforcement officials and prosecutors the tools they need to keep Canadians safe. And this is important, Mr. Chair. Soft on crime liberal policies have created chaos in communities across Canada. Since 2015, police reported hate crimes in Canada have increased by 258%. Extortions are up 330%. Anti-Semitic hate crimes alone are up 416%. Hate crimes against South Asians have risen by almost 380%. In 2014 alone, Canada saw almost 5,000 police reported hate crimes, the highest number on record in Toronto. In Toronto alone, hate crimes occurrence jumped by 19% in a single year, with assault-related hate crimes rising by 42%. Addressing the issue of crime is incredibly important to my community of Brampton West, and it is my duty as a parliamentarian to try and find solutions to make my community safer. However, instead of taking action on our shared objectives and finding solutions to addressing this explosion of hate crimes in our communities, we are stuck debating the Liberal bloc backroom deal which directly assaults freedom of expression and religious freedom. I want to draw the attention to members of two recent news stories talking about hate crimes in my community. The first is from October 16, where a man assaulted a victim with replica firearm after hurling racial slurs in Chinguacousy Park. The second is from November 15th, where a 22-year-old man was charged after he struck a pedestrian with his car after yelling racially charged comments. Both of these reported hate crimes have been committed since the start of this committee's study on Bill C-9. This is what I mean when I say that this is an incredibly important issue in my community and why I am so upset that we are wasting our time on the Liberal bloc plan to strip Canadians of their charter rights. For a party which brags about being the party of Canadians' Charter of Rights and Freedoms, the Liberals clearly have not read the document. The very first fundamental freedom laid out in our charter under Section 2A is freedom of conscience and religion, followed by freedom of thoughts, beliefs, opinion, and expression in Section 2B. Those fundamental rights are what Mr. Brock seeks to further enshrine through his sub-amendment. Section 319, subsection 3B and 319, 3.1b of the Criminal Code exist to protect those fundamental freedoms in the Charter. These committee heard just that from Derek Ross of the Christian Legal Fellowship on October 30th. When questioned by the bloc about repealing those two sections, Mr. Ross stated that these sections have been pivotal in demonstrating to the courts that the legislation does strike the right balance and does not intrude too far on citizens' right to freedom of opinion and expression. He went on to add that if the good faith defense or the other defense for truth as examples were removed, we would be concerned that could undermine the constitutionality of this regime and the careful balance that has been struck. To back up their attempt to undermine Canadians' constitutional right, the Liberals and Bloc rely on extreme or made-up scenarios as to how the good faith defense could be abused. The only issue with that argument is that there is no evidence to back it up. In the 2023 case in Quebec, which the Bloc cites, there were never charges brought, and even if there were advocation of genocides of Jews is most certainly not good faith. Our courts have been consistently interpreting sections 319(3)(b) and 3.1b very narrowly. Mr. Ross spoke to that effect, stating the example the bloc often cites would be both a misuse of both the defense and, frankly, of religion. Our courts are aware of that fact as well as, Mr. Chair, the committee heard from the Canadian Constitution Foundation on November 6th. These sections have never been successfully invoked, and that their existence are central to the court's conclusion that the current law is constitutional as it is. Mr. Ross told us that the courts have been very clear that this defense cannot be used to cloak hateful expression with impunity. The language they use is as a Trojan horse to carry the intended message of hate. Mr. Chair, removing provisions of the criminal code which are central to our court's interpretation of our laws and Constitution, I would use another metaphor from Greek mythology and say that this will be like opening a Pandora's box. We have no idea what kind of horrors could be released on our communities if the Liberal bloc proposal is passed. Our system of good faith protection is working, Mr. Chair. We heard that from witnesses after witnesses in this study. What we also heard from witnesses at this study is that after 10 years of Liberal soft on crime policies, there are so many things in our criminal justice system which are not working and need to be fixed. We could be talking about bail reform. We on the side of the committee have tried numerous times to get started on our
Mr. Chair, I have a point
study
of order.
bill of Bill C-14.
Ms. Latanzio?
Yeah, once again, I would invoke the point of relevance in terms of C-14. We're on C-9, and I have tried since this morning to outline that the Conservatives are obstructing the study and the final study of clause by clause on C-9. And because of that, we are not able to move over to C-9, finishing C-9, nor are we even able to begin the study of C-14. So, Mr. Chair, I think it's a bit rich that we start invoking the fact that we don't want to study C-14. The Conservatives have been clear ever since Tuesday that they do not want to study C-14. It's obvious.
Thank you.
So that is why I brought forward those motions seeking unanimous consent, Mr. Chair, to bring this to the chair, to the House, Mr. Chair.
I understand your point. Thank you. Mr. Gill, I've been very, very generous in terms of how broad people can go with their comments, and although some may not agree with that assessment, I think I'm being accurate when I say that. But if you could try to keep the focus on the amendment and the bill we're dealing with, I would appreciate it.
Absolutely, Mr. Chair.
Thank you, Mr. Gill.
Quite a long time I was reading about hate crimes and how they are impacting our communities and society. At the same time, violent repeat offenders are on the bail, and C-14. I'm just going to get to the relevance before anybody, and this is their right to make point of order, and I don't complain about that, but if they will allow me, they will see that how I'm coming to my points. And whatever I'm going to talk is very important for us as a lawmakers and important for Canadians, Mr. Chair.
I understand, Mr. Gill. I'm happy to give people lots of latitude. It's just
thank you.
Try to keep it close. That's all. Thank you.
Okay. So I would again say thanks to Bill C-5 and C-75 by Liberal government, our system of bail is broken in Canada. Violent and repeat offenders are back out on the
Mr. Gill, I
streets.
apologize. We have another point of order. Ms. Latanzio.
Mr. Chair, once again, we're talking about bail reform, and there's no relevance with regards to the Second Amendment put on the table. If my member opposite wants to deal with C-14, obviously we're not going to be able to get to C-14 as long as they keep on obstructing the finalization of C-9. And if that's the case, Mr. Chair, that's why I've moved this morning that we seek unanimous consent, because we're never going to be able to get to C-14 in this committee, that we send C-14 for third reading in the House.
Thank you. Mr. Gill, if you could bring it back to the bill at hand. I understand people's desires around this table. It's been made very clear time and time again, frankly. But if we could redirect the focus very, very quickly, we can avoid further points of order. Thank you.
I think it's entirely within the member's right to discuss the direction and the priorities of this committee. And I appreciate...
That's not a point of order. That's a point of debate, Mr. Barber. Thank you very much. Mr.
Well,
Gill.
this is debate against Mr.
Well,
Tanzer's
Mr.
point of
Barber,
order.
it's a
Thank
point.
you.
You're getting into debate, which we're not going to do. Mr. Gill, you have the floor.
Okay. I understand, Mr. Chair, your point of view, and as Mr. Barber said, I am coming, but I just did not even finish a line, and the next point of order came in. So they will see the relevance when I will going to my next paragraph as well. So my focus is also to have safe communities, and I do not want to see any sort of crime, whether it's a hate crime or violent repeat offenders, whether it's C-9 or C-14, any kind of criminals should be out of the street. They should be where they belong, which is, I always say, I want to see them in jail, not bail. So I will say violent and repeat offenders and hate crime offenders are out on the streets hours after being arrested for crimes. This is a major issue in my community. This committee heard directly from the mayor of Brampton, Patrick Brown, as part of this study. I want to quote from his testimony to highlight the urgency of this issue to my constituents. Mayor Brown first told committee members about Darian Henderson Bellman, who lost her life to 5 shots from her former intimate partner. This individual was released on bail 5 times. It was a preventable tragedy. A violent repeat offenders.
Point of order. Mr. Chair, relevance.
Mr. Chang.
Relevance.
Relevance. Mr. Gill, you did promise that she would get back to it in your next paragraph.
Okay.
If you want to cede the floor to Mr. Barber rather than take instructions from him, that's okay too.
Okay.
All right.
One thing I would like to say, Mr. Chair, we need to get acting on a bail reform as well, but Minister Fraser was quoted yesterday saying that he will personally, over the next number of weeks, going to be engaging as well as to make sure that we gully first understand the nature of the concerns being addressed. If the minister is going to be talking the next few weeks to consult further on the mistake he has made with his deal with the bloc, we too at this committee should not rush to finish the clause-by-clause review of Bill C-9. We too should take a few weeks to reflect on those proposed amendments and instead devote our time to more pressing matters such as Bill C-14. And I would like to bring the motion at the end, Mr. Chair. Given that the Minister of Justice is in Ottawa today, the committee invites him to appear immediately in relation to Bill C-14 with respect to bail and sentencing, followed immediately by clause consideration of C-14, followed by clause on Bill C-9.
Sorry, there's a lot of conversations going on in the room, Mr. Gill. Can you repeat what you just said?
So at the end, I said I would like to bring a motion. Given that the Minister of Justice is in Ottawa today, the committee invites him to appear immediately in relation to Bill C-14 with respect to bail and sentencing, followed immediately by clause consideration of C-14, followed by clause on Bill C-9.
Mr. Gill, the motion, you can't bring that motion at this time. If you're seeking unanimous consent, we can proceed that way, but we've done that.
Can I ask for unanimous consent?
You can ask, yes.
So,
do we have unanimous consent? No.
Yes.
Okay, thank you. Okay, are you finished, Mr. Gill?
Yes, I am.
Okay, thank you very much, sir. Next, we have Ms. Wagenthal.
Well, thank you very much, Mr. Chair, and I'm very pleased to be here today, not just to speak, but to first hear from other colleagues. And
I'm sorry, Mr. Chair. I'm sitting right
Yeah,
next
okay,
to Ms.
look,
Wagenthal, and I cannot hear her.
I hear, I haven't
I
come
did,
myself.
however, hear
If
some
people
really
in the room,
unfortunate
please,
comments from
in the
over here,
back,
like-
on the sides, all round, when somebody is speaking,
Excuse me, could you go somewhere else?
when
There's
somebody
sound
is
rooms
speaking,
all over.
please show
not
some
fine now,
respect
so if
so
you wanna
that
have a
people can hear them.
conversation,
Mr. Mantle, I've got this under control. Thank you. I don't need help. I still don't need your help. Thank you. Mr. Mantle, again, we can have this banter back and forth, and Mr. Jennings is now joining in on the fun. I've made my request. It's pretty clear. Ms. Wagenthal, you have the floor.
Thank you. It's Wagenthal. No worries.
I should know that by now.
My
My
own leader
apologies.
has a problem with that once in a while. I think I'm going to take a bit of a different approach to this. I think it's really important that as we're speaking here, people understand who we are and where we come from and what our values are. It basically impacts how each of us performs in this place and who we represent. So first and foremost, I'm a Christian. I love my faith. I depend on my faith. I teach my faith to my children. And my husband and I are of one accord on that faith. And we have an incredible privilege in this country that makes it so attractive to so many different people, even now, as it did back when my grandparents came to Canada under duress from where they had to leave. To be able to come here and know that you have opportunity to be yourself and to have the right to express yourself and to discuss and debate and talk in the public square about your faith. This is something that every person that comes to Canada has the opportunity to do, and it's been abused extensively over this last decade. And I had the opportunity to go to India with my husband. Yes, I need to go again. We need to go everywhere in the world at least 3 or 4 times, which we don't have a lifetime to do. But we went to the Lotus Temple and where Mr. Gandhi was buried. And, you know, inside, every book at that time of faith is displayed. And the idea is, with that, of course, is that every religion has its opportunity and its right to exist. Now, our Bible was sitting there, and you could go and look at them. But honestly, my husband, who is a pastor, looked, and it couldn't have been open to a more ambiguous portion of what this book represents than what was on that page. So my husband, being who he is, said to the individual overseeing, protecting, could I please change what page our scripture is showing? And of course, he wasn't able to do that. But the point being, for someone who is a politician to stand up in this place as a leader of a committee and declare that a portion, a segment of this holy book is hateful and means that whoever reads it out loud or shares about it should go to prison is unacceptable. And it is unacceptable. It is unacceptable to everyone in this place, and I'll tell you why. In the House of Commons, standing in my place and speaking, I was asked a question, but it wasn't a question, and it came from a Bloc member who said to me, you have no right to bring your faith into this place. No, I'm just repeating what I was told. So my response simply was, we all have faith. You have faith. Or that individual, Mr. Speaker, has faith. It's just a question of where you put your faith. And so we are treading on various dangerous ground as a government by going this direction. And I think the government has been made aware of that fact. And I can assure everyone in this room that is studying these issues, you have opened up an incredible can of worms that you do not want to deal with. That's not a threat. That's just a reality. Because there isn't a single faith in this country that hasn't risen up in arms against this, because it is inappropriate for our government to be once again trying to control the lives of Canadians. It came to family decisions about parental rights. This government has challenged that. Confiscating law-abiding owners' firearms. Freezing Canadians' finances. And now attacking our faith is inappropriate. And I have had many people come to me who came here years ago under duress, seeking freedom and the opportunity to worship God. And this generation of the hundreds of thousands of immigrants that have ended up in Canada are saying to us, this is not what we expected. We want to leave. We want to go somewhere else. This is no different than where I came from. That is a huge statement against our country. So it needs to be dealt with. And the very fact that this is before the House, or before this committee now, I think in ways that it wasn't expected that C-9 would be dealt with, says that this has got to be removed. And you've heard that from people all over this nation, people with authority within faith, everyday Canadians, people from all different kinds of civil liberties groups, because what this government has done is opened up for a second time the hearts and minds of Canadians and those who are calling this place home to say, not on my watch. It happened before, and during that time, I was also subject to this government's overreach, where I was not allowed to exercise my responsibilities as a member of Parliament because the government was telling me what I could and could not do. Unacceptable. And as a result, there was a swelling across this whole nation that grew all the way to this capital. And in that group of people, that huge group of people, you know what? Every people group was represented. It was not what the Prime Minister of the time and others have said was representative of our nation. And it was abusive, and it did not reflect the incredible pride of every group of people represented, from Indigenous to Indian to European, you name it. Every faith was represented in that. And here we are again today in a situation where Canadians are coming together to say no, and that this bill in its entirety needs to be scrapped, let alone what's come forward since in the amendment that was brought forward that basically attacks our faith. This began, I've been here for a decade. It began in my first year here with the shutting down of the Office of Religious Freedom. That's what this government did. They brought in M103 to divide. We tried to amend it to include every faith in this country. They denied it. They did not support it. And our personal autonomy has been basically abused. So this is moral injury. This is moral injury. And I think what the government doesn't understand, in the same way as with Veterans Affairs, where I've served for a decade, I'm the old matron on the team. It's changed makeup every time there's been an election, many different leaders on both sides of the floor. But having been there and hearing stories over and over again about moral injury, what our veterans have experienced has caused them to become dismayed, despondent, discouraged, and as we just finished a study, many of them seeking suicide because they cannot cope anymore, at the same time as being encouraged to do it in another way. But what we have learned at that committee, which I find just astounding, is from 3 different organizations, one of them Mr. Romeo Delaire's, that we cannot solve these kinds of problems when they're moral injuries with just treating the body with pharmaceuticals and the mind, because we have this third part that's actually the pinnacle of the triangle, and that is your soul. And until we deal with the reality of the soul, you can never fully heal. And what this bill is doing is trying to disrupt Canadians' health like they have done in so many other ways constantly. My riding has been so engaged on every level since I became a member of Parliament. They get exhausted in trying to respond to this government. And here they are again, rising to the surface and saying, this is wrong, this is inappropriate, this cannot happen. And as a result of this divisiveness that's happening truly in our nation, the level of hate is real. It's been encouraged. I'm sorry, it's been encouraged. And divisiveness is causing that. So the reality, and I'll just quote one thing here. People of faith and faith leaders have been writing to the Prime Minister, and they are expressing their deep concern about the removal of religious freedom exemptions from the criminal code. You know why? Because they also know it will not make Canadians safer, and certainly not protect any people of any faith from hate. It's spin when you say we're trying to protect people of faith from hate, when you turn around and are creating the hate. So this has to end. And we know, witnesses have told you at this committee that the religious text defense is narrow and does not offer blanket immunity as the Liberals are trying to suggest. As they're saying, trying to veto or shut down faith texts is not going to bring safety to Canadians. The good faith religious defense protects minorities and those with sincere held religious beliefs. The separation of church and state is being used inappropriately because Thomas Jefferson in 1802 wrote one letter to a Baptist group who were concerned about the freedoms that they had, and he said, you do not need to worry, because separation of church and state, as he was referring to, meant not protection of the state from the church, but the church protection from the state. And that is the circumstances that we are finding ourselves in today. First of all, with the shutdown of the Office of Religious Freedom, trying to pit one faith group against another, removing charities. All of these things are things that Canadians are seeing, and they are not foolish, they are not fooled, and they know that this is inappropriate. Religious communities, including Jews, Christians, Muslims, Sikhs, Hindus, and Buddhists, hold a vast range of beliefs on religion, on morality, on sexuality, politics, and culture. I go by my faith in the Word of God, but it is not government's job to dictate what people believe. It is actually something called free will that every person has to make those decisions on their own, and it is not the government that should be controlling the free will of people. Though some may find different beliefs objectionable, I don't agree. I love to debate with people of other faiths. We should have the confidence. My husband, as a pastor, has told young people all their lives, if your faith is true and you know and understand it, you can talk with anyone else about their faith and what they believe. We are not there to threaten each other. We are there to have reasonable conversation because every person in this place, every person in the world has a soul. And that shows by the extent of faith belief across the world, including secularism. I'm sorry. That is faith. That is a religion. My religion happens to be a relationship. It's not me trying to figure out and get to God. God has come to me. That's my faith in a nutshell. So some of these beliefs we may find objectionable or old-fashioned or even hateful. A free country does not criminalize the expression of sincerely held religious doctrines. We have laws in place that this government has refused to use. With obviously then, I'm sorry, you have to ask the question, why is that? If you have an opportunity to deal with hate, why would you not be dealing with it? What is preventing you from doing that? The courts have been clear that violence and calls to violence are not and never have been protected as free expression and are not in good faith as the defense requires. And that's why we have laws. And I would just encourage this government to get back to, and I will not bring forward a motion or whatever, but the reality is the depth of darkness in crime and everything going on in this country that is negative is due to this government not doing its job in those areas. And that bail reform bill needs to be dealt with. It is not the fault of these people who are here today representing Canadians on Bill C-9 and on this particular amendment that has risen the angst of Canadians. It is the responsibility of this government to deal with that, get it out of the way, remove it, and get back to dealing with the issues around crime in this country and jail, not bail. Thank you.
Thank you very much, Ms. Wagenfeld. Mr. Au, over to you, sir.
Yes, thank you, Chair. Thank you for allowing me the opportunity to speak. I'm not a permanent member of this committee, but I feel compelled to speak today, mainly for two reasons. For one, I'm really concerned about the what is unfolding here in this committee. I came 2 nights ago, and I saw that the amendment was passed to remove the good faith defense from the bill. So that I think what is happening is really dangerous. And not only that, I feel compelled to speak because I have received hundreds of emails and messages in the last few days. And I would say that none of those emails that I received would support removing the good faith defense from the bill. And these people, they urge me to speak for them because they don't have the privilege to speak in this committee or in the parliament. So I'm going to share some of the messages that I received later on. I will speak directly to the amendment and the sub-amendment. Now, before I share the messages that I received, I want to give you a little bit background about my writing and myself. My riding is Richmond Center Maple, which is the most culturally diverse riding probably in the country. We have 60% of our people not born in Canada. And we have 75% of our population being identified as visible minorities. So we have people coming from all over the world. We have over 110 languages being spoken at home or in the community. So we have people coming from all walks of life, all kinds of religious background, and all kinds of cultural background. So I think this is quite something when we put into a debate of this bill. And personally, myself, I came to Canada in 1988 for the reason that I want to find a place that I can practice my faith without fear. I don't have to fear about whether or not I would be allowed to practice my religion, whether or not I can speak freely about my beliefs, and whether or not the Bible, and the other religious writings that I have would be subject to censorship. So that's why I came to Canada. And I believe many of my people in Richmond, Santa Marble, came for the same reason. And I think they were being alarmed by seeing what's happening in this debate for Bill C-9. Now, I want to, as I said, right, I want to share some of the messages that I received. For example, one message said, if Scripture can be put on trial for being offensive, then religious freedom itself is on trial. The other one said that if passages are labeled hateful, then tomorrow's target could be the Bible, Quran, or Torah. And on the, the other day, my colleague Tamara Corres, she gave a history about the constitutional development of Canada and how we arrived at a balance between protecting religious freedom and protecting of people from hate. And in response to that, one senator said to me, when Parliament forgets its own constitutional history, it repeats its constitutional mistakes. And the other one said that religious oppression does not begin in faraway countries. It has happened on Canadian soil. And another one said that every slide in repression begins with small, reasonable sounding steps. And on the amendment being proposed by MP Andrew Lawton, one of the senators said this, Andrew Lawton's amendment is not a loophole. It's the last line of defense for freedom of expression and religion. And finally, another person shared with me saying that, listen to this, once government is given power to prosecute without limits, it will use that power,
Mr. Chair,
and eventually against someone you didn't expect.
Ms. Latanzio, sorry, we have a point of order, I believe.
Yeah, point of clarification, actually. I just heard the member opposite speaking about Mr. Lawton's amendment. Maybe he should be reminded that we are on Mr. Brock's sub-amendment.
Thank you. That's a good reminder. We are dealing
maybe
with
just
Mr.
Yes,
Brock.
I know that, but I'm just sharing some of the emails that I received in the past few days, just for the information of the committee, so that you know where I'm coming from when I come to this discussion.
Point of order. Just a point of clarification, just so that the member knows, so that I
just a point of
I can
clarification.
appreciate if it's relevant or not, his intervention.
Yeah, no, I understand. I understand. It's just a general reminder again to try to keep it focused on the matter at hand.
Of course, as I mentioned from the beginning, that I'm going to speak directly to the amendment and the sub-amendment.
Continue,
As I
Mr.
said,
Elsie.
I'm going to give the background of the kind of emails, messages that I received in the last few days.
She's quite right. We are on the sub-amendment.
Yes.
Thank you.
Okay. Then I also believe that my colleagues on the other side, you may have received similar emails. You may be also struggling with these kinds of concerns, whether or not you support the amendment or not. Now, from what I heard and observed, I believe that the amendment made the other night to remove good faith defense is a very dangerous move, because it would lead Canada into a slippery slope that once we get into that kind of path, there's no way that we can come back. The question, as I mentioned from the context that I outlined earlier, the question that's been posed on me and I believe my other colleagues is that if passages of Scripture can be decided to be hateful or offensive, what is coming next? It will only be logical to deduct that if parts of the Bible or a religious scripture is being deemed as hateful, at the end, maybe the whole book itself could be seen as hateful and be banned. And it's not that we have not seen this happen in other countries.
So what will happen next? Are we going to have redacted versions of the Bible? Are we going to have clean versions of the Bible or other religious writing approved by the government? So I think this is a logical question people ask. And I think we have to address it in our debate on C-9 and the amendment that was being passed. Now, don't laugh at this. Don't say that this will never happen in Canada. What we've already seen is that in many school districts, books being written by Greek authors such as Charles Dickens and Shakespeare has been banned from schools for the reason that some school districts deem those writings, those novels, being discriminational, being racist or sexist, or not up to the modern standard. So it did happen. So there's nothing to prevent that once we enter into this slippery slope, that kind of thing, to ban or to have a clear, clean version being approved by the government will happen. The other night, my colleague talked about the history, how we arrived at a good balance between protecting freedom of expression, freedom of religion, and also protecting people from hate crime. I think that is a good lesson, a good history for us to learn. I understand that some of my colleagues don't want to hear that. They challenge, saying that, oh, you're giving me a history lesson. But I think we need to learn from history. As one of the sender of the message to me said that this has happened before. Canada is not immune to religious oppression. I think some of us here who have been living in Canada for a longer time might still remember at some time between 1940s and 1950s, there were religious oppression to a group of faith community in Canada. At that time, I was told, and I've learned, that the Jehovah's Witness communities was under oppression. Their homes were being raided, their gatherings were being banned, and also they were being persecuted. So don't say that this will not happen again if we do not learn from history. I also agree with, as I mentioned, one of the messages that I received, saying that we need a safeguard against what has been approved as the amendment to Bill C-9, again, which is to take away the good faith defense. I believe that whatever reason the amendment was brought forward, the intention was not to suppress or take away people's religious freedom. So I believe that the amendment by Mr. Lawton and also the sub-amendment by Mr. Brock is going to make this even more clear. It's not taking away anything that has already passed the other night. But this is to clarify even further for the general public that it was not the intention to go onto the path of oppressing religion's freedom. So I don't see why the amendment and sub-amendment could not be supported. It only serves the purpose to clarify further and to tell the people of Canada clearly that was not intention of the amendment or the bill itself.
Point of order. A point of clarification, Mr. Chair.
Yes, Ms. Latanzio.
I was just wondering if the member can explain or maybe tell me if there's not a contradiction between the amendment and the sub-amendment. I have a question. I have a clarification. I just want to understand.
Thank you, Ms. Latanzio.
He's talking about the amendment and the
Ms.
sub-amendment.
Latanzio, you can address the chair. You can ignore
It's just
Mr. Dennis.
an amendment and a sub-amendment, and I'm trying to understand if maybe the member can tell me if does he not see that the two are they contradict one another.
Thank you for the question. I don't have Mr. Lawton's amendment before me, but I remember it's very clear in his amendment saying that for the purpose of clarity, the amendment being passed was not targeting religious freedom or freedom of expression. And the amendment being presented by Mr. Brock today is further clarification. This is not to target freedom of religion and freedom of association and freedom of peaceful assembly. So it's directly relevant to the amendment and the sub-amendment. As I said, right, it's only to clear and to clarify further that this is not we are trying to arrive at. We are making a distinction that for whatever reason the Bloc and the Liberals make that amendment is not what they want to do at the end of the date. So I also want to appeal to my colleague from the Bloc Quebecois. I think in Canada, you know, you are the community who knows best. When you give the government unlimited power, it can come back to you. And you could be the victim of the power you gave to the government. So again, I don't believe that my colleague from the Bloc Quebecois moved that amendment for the reason that they want to to oppress religion. So I hoped that they can support the amendment and the sub-amendment to make this very clear so that they would not be misunderstood by the rest of Canada or people who have questions about why that amendment was being moved. So with that, thank you, Mr. Chair, for giving me the time to speak.
My pleasure. Thank you very much, Mr. L. Mr. Brock, I believe you're next.
Thank you. What I'm about to say, and I would ask every member here to grant me the indulgence, because I think what I'm about to share with you is going to please my Liberal colleagues. But I'm asking for indulgence. It is abundantly clear, after several days of debate on C-9 and numerous motions and numerous requests for unanimous consent to prioritize Bill C-14. I've lost track, I've lost count, but we're probably looking at a couple of dozen, conservatively, pardon the pun, over the last several days, or liberally. But it was important because I think we've all heard from every major stakeholder across this country. Canadians, premiers, law enforcement, mayors, victim advocacy groups, crying out for a government response to a crime epidemic that seems to be rising year after year after year. I'm not expecting my Liberal colleagues to agree with this, but clearly for 10 years, ill thought out and ineffective criminal justice policies have contributed in a very large degree to a crime crisis. So it's clear that any attempt to move forward with a unanimous consent motion and a motion to deal with C-14 is not going to be met with approval. We understand that. In the spirit of the season and in the spirit of addressing what every stakeholder I've identified asked us to address, I am asking, and not to be accused any further of any obstructionist attempts, and I know that we've made the same allegations regarding the Liberals obstructing their own pieces of signature legislation. We've waited several months, in fact, almost 8 months post-election for our Justice Minister to introduce reforms to bail. And while it is not a perfect bill, it does address issues that are germane and had been requested by law enforcement. So bearing that in mind, Chair, I am asking, and bearing in mind the comments and the unanimous request for unanimous consent that Ms. Latanzio had presented to this committee maybe an hour ago, I am now asking for unanimous consent for all the voting members at this committee that we move C-14, we report that to the House immediately.
I didn't think I'd be saying this today, but I think we have unanimous consent.
No, Monsieur le Président.
No, Mr. Block.
Pouvez-vous...
I would ask for a suspension. I know it's not customary, but I would like to consult.
He has to ask Blanchet if he's allowed to. Interesting. I kind of see what Brock's doing there. Is he's genuinely concerned about what C-14. C-14 is the Liberals' proposed revisions to the bail system. And like Brock said, it's not a perfect bill, but it does address some of the concerns that police have had regarding the way bail works. So instead of debating it, because we're obviously going to be stuck on Bill C-9 for a while, who knows how long, because this is just one giant filibuster on both sides of the spectrum. Brock's like, okay, if we're not just going to debate it, let's just move it to the House, and then it can be voted on in the House. That's basically what's going to happen there. What's C-14? It's bail reform. I just mentioned that. It's bail reform. So I guess the Bloc wasn't sure, because it looked like Libs and Cons were on the same page there. The question was whether or not the Bloc is going to be okay with this. Was this from yesterday? No. This is live happening right now. So we'll just see how long they take. We can tune into the House in the meantime. And we will come back to this as soon as they come back. Dun, 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 dun. Oh, the House is suspended too. How long is the House being suspended for? Half an hour. Holy crap, the House is being suspended for like over an hour. When did they suspend? Why is the House being suspended for this long? Interesting. They've been suspended for like 2 hours. Or longer. The House is suspended? Yeah, the House itself is suspended. Does anybody work in Ottawa? I know. They literally get 6 weeks off. This is like the second last day that the House sits. And yeah, so this was at around 11 o'clock. So it's being suspended for almost 2 hours.
I was consent to call it to suspend till 2 o'clock.
Suspend till 2 o'clock. So yeah, a 2 hour suspension. Interesting. And then it was granted. Of course Kevin wants some time off. He's always living in the House. He's like, I gotta do something. So there's nothing for us to really watch in the meantime. Let me see if there's anything like if there's anything else. No rhyme or reason. No, he just asked for the House to be suspended till 2 o'clock, and saying as there was nobody else really in the House, it was just Kevin. He got the unanimous consent because there was nobody to say no. So, honestly, on Brock's point, there are a lot of flights being booked out of Ottawa, obviously today, because it's not just the House of Commons and all the staff and the translators and the tech guys. There's many other bureaucratic things that take a break for the winter. So I imagine the flights are probably, probably fully booked up for today. If Kevin knows everything and is always in the House, why isn't he running for Liberal leader and become PM? He seems to know everything. He's too unhinged. Everyone is in committee. All the committees are done for the morning and the afternoon. The only one that's still going, which is suspended, is the Justice Committee. All the other committees have adjourned. They all adjourned around 12 or 1 o'clock, so they've been adjourned for over 24 minutes. And it looks like they've even canceled two committees in the afternoon. HUMA was supposed to sit at 3:30, and the Agriculture Committee was supposed to sit at 3:30. Both of those are canceled. Looks like the only one that's going to be left in the afternoon is OGO and Justice if they end up coming back. No QP today. Yeah, we're going to tune into QP in half an hour. I've already made a link for it on the channel. And then after QP, we'll either watch OGO, or if Justice is back on, we'll watch the Justice Committee. So, and that'll be it for today. I'll put the link in chat for question period. That's the link for QP. So it's 12:30 in Ottawa. No, it's 1:30. It's 1:30 in 1:25 in Ottawa. Also, we will cover QP tomorrow. I usually don't do QP on Fridays, but since it's the last day that will go live for this year, it should be around 11 o'clock, I believe. 11 a.m. is when QP starts on Friday. So we'll watch that tomorrow, and if you want to come for it, cool. If not, I don't really expect anybody to be in the House at all, and I wouldn't be surprised if they just adjourn right after question period. They're ending the House today. Let me see. No, it still shows sitting day tomorrow. It still shows a sitting day. $69 days. Yeah, I know. They do. They get way too much time off. Somebody said it in chat earlier. We said this yesterday. Everybody comes back to work early January, right after New Year's. I don't know why they need a whole 3 weeks in January. Like, they don't sit till like the last week of January. It's too much constituency time. It really is. And also, I think MP pay rises should be freezed for at least 5 years. I mean, their base salary is $200,000, and then they get extra stipends for being on committee or for being a minister, or it's far above and beyond what the average salary in Canada is like $55,000. So imagine making like 4 times that and getting all your expenses covered. Wow, 69 days full of work. Yeah. Considering how much they get paid, yep. Work 2.5 months to get $200,000. It shows it still will, but I wouldn't be surprised if they took it off. Most of them go on tropical vacations. Yeah, that is true. $2,900 a day. I mean, this isn't even including some of the expenses that we've seen this year. What was it? Carney's $800,000 one return flight to Egypt. There was the Lib MP who earlier this year expensed $192,000 for what she called some of her staffers. There was Gregor Robertson recently with the $100,000 just to do a one-day convention on homelessness. Plus benefits, plus expense accounts. Yep, exactly. It's just insane. It's too much. Instead of us staring at a blank screen, let me see if there's anything else we can watch. Dun, 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 dun. Usually don't watch the Senate, but we could see that. Bet you the Senate's going, and Parliament isn't. Yeah, the Senate's actually sitting.
I move that the report be placed on the orders of the day for consideration at the next sitting, which of course will be next year. Happy holidays, everyone.
It is moved by the Honourable Senator Bean, seconded by the Honourable Senator Wu, that this report be placed on the orders of the day for consideration at the next sitting of the Senate. Is it your pleasure, Honourable Senators, to adopt the motion? Adopté, carried. Senatrice Odette.
Senator Odette. Honorable Senators, I have the honor to inform the Senate that pursuant to the order of reference adopted on October 7th, 2025, the Standing Senate Committee on Indigenous Peoples deposited with the Clerk of the Senate this morning on December 11th, 2025, its second report, interim, entitled Voices of Youth Indigenous Leaders 2024, and I move that the report be placed on the orders of the day for consideration at the next sitting. It is moved by the Honourable Senator Odette, seconded by the Honourable Senator Mugley, that the report be placed on the orders of the day for consideration at the next sitting of the Senate. Is it your pleasure, Honourable Senators, to adopt the motion? Carried.
Senator Black.
Honourable Senators, I have the honour to table the first report of the Standing Senate Committee on Agriculture and Forestry, which deals with the subject matter of those elements contained in Division 8 of Part 5 of Bill C-115, an act to implement certain provisions of the budget, tabled in Parliament on November 4, 2025.
Conformément à l'ordre adopté le 26.
Pursuant to the order adopted the 6th of November 2025, the bill is placed on the orders paper. The report, rather, is placed for the order papers for the to be examined at the next sitting of the Senate.
Of the Standing Senate Committee on Agriculture and Forestry, which requests that the committee be empowered to incur special expenses. The Standing Senate Committee on Agriculture and Forestry has the honor to present its second report.
Votre comité qui a été autorisé par le Sénat.
Your committee, which was authorized by the Senate on Wednesday, October 22nd, 2025, to examine and report on the role of the agriculture and agri-food sector with regard to food security in Canada, respectfully requests funds for the fiscal year ending March 31st, 2026, and requests for the purpose of such study that it be empowered
Travel Inside Canada, conformément au chapitre 305, article 1.
Pursuant to Chapter 305, Section 11C of the Senate Administrative Rules, the budget submitted to the Standing Committee on Internal Economy, Budgets and Administration, and the report.
Okay, the Justice Committee's back.
Je réponds, Monsieur le Président, à la demande de consentement unanime.
I will say no to this request for unanimous consent.
Why block? Bro.
Okay, Ms. Latanzio, do you have a comment?
Again, in the spirit to be able to find a solution here and perhaps a compromise, I'd like to move a motion, and I'm going to read it. I only have the English version of this.
Bruh.
So I'm going to read it out.
What is with the block, man? Liberals and conservatives
Okay.
are agreeing on that.
I move that the committee invite the Minister of Justice and Attorney General of Canada, Sean Fraser, to appear for 1 hour on Friday, December 12th at 9 a.m. to testify on Bill C-14, an act to amend the Criminal Code, the Youth Criminal Justice Act, and the National Defense Act, bail and sentencing, and that upon the conclusion of the minister's testimony, the committee proceed immediately to a resumption of consideration of clause by clause on C-9, an act to amend the Criminal Code, hate propaganda, hate crime, and access to religious and cultural places, and that all amendments be deemed moved and put forward without further debate or amendment, and that the committee does not adjourn until clause by clause of C-9 has been completed, and that the chair be instructed to report C-9 back to the House at the earliest opportunity.
I don't like that last
So can
part.
we get that, can we get that, translated in French?
Suspended, yeah.
Bro, oh my God. They have suspended this committee like 9 times today. So I don't mind what that proposition was. In fact, that was quite all right to at least have some compromise. But what she's saying is fine. We'll let you have the Justice Minister tomorrow, and we'll sit tomorrow. But that means that all amendments and everything that's already being put forward on C-9 goes immediately without debate.
Which takes us to Mr. Dalton.
Thank you very much, Chair, and I do appreciate the opportunity just to share a few moments on C-9 and the motion and the before us. And as probably most members in the House is happening right now, receiving a lot of correspondence, people that are very concerned about this bill, the impact upon their.
Mr. Brock.
Normally, and I generally refuse to point of order a colleague, and I hope he forgives
We're
me.
all colleagues here, just for the record.
Well, an internal colleague. Okay?
All right.
As opposed to external.
Okay, all right.
An internal colleague, and I apologize to Mr. Dalton for that purpose, but I have a proposal seeking unanimous consent that we take the first part of Ms. Latanzio's unanimous consent reference to the Minister of Justice appearing for 1 hour on December the 12th. I don't know if she mentioned a particular time. And then everything else that she had to say with respect to reporting back to the House without amendment would be satisfactory to our conservative team, and I would be seeking unanimous consent on that. No reference to C-9. Okay?
We do not have unanimous consent, so Mr. Dalton, please proceed.
Thank you. So, as mentioned, receiving a lot of correspondence on this bill, a lot of people that are very concerned, Canadians from coast to coast that are quite often, not really thinking about politics and about the impact upon their own lives, as much as we might be wishing they were. They they're writing, they're saying, how is this going to impact me? And I would say I'm quite concerned about the bill before us. I know that's the reason why we have the motion. Just an important fact is that the government legislation already has the tools that it needs to prosecute those who promote hate and genocide. It already has the tools that it needs to prosecute those who promote hate and genocide. I see this bill as politics. Surprise. And bad politics. And bad for Canadians. It's hard to believe that this legislation before us is here in Canada. We've been known as a country, as a beacon of freedom. People from all over the world have immigrated here. And this seems quite contrary to the values of freedom, of faith, of expression that we have had over generations. So this is an extremely important bill. And for me, it really reminds me of the direction of other states that have, I would say, banned scriptures, different scriptures. I think of countries like China in the past under Mao, communist Russia, communist regimes. Scriptures were banned. I actually have some friends that were involved in smuggling not drugs, not arms, smuggling Bibles into the former East Bloc communist countries, where people would be imprisoned, people would be tortured for their faith, for having a Bible. Now, it moved in other countries like China later on. They said, okay, well, you know what, you can have the Bible, but here's what you can believe, or here's what you can say. You take off this section and this section and this section and this section. Tell me what is the difference here that was before us, Mr. Chair? You don't have to, that's a rhetorical question. Okay. This is the same direction. And I think we need to talk about direction before us. This is a bad direction, whether you are a person of faith that is Christian or Muslim or Jewish or even a secular, because you know we're talking about fundamental rights for all Canadians. And it's something I think we shouldn't be going in this direction. Now, personally, I'm a Christian. Okay, my faith is fundamental to who I am. It's much more important to me than being a parliamentarian. And it informs everything about the direction and values. It's a light upon me. It's personal. And this motion before us talks about, it expands, saying, hey, this needs to be more than just the faith. It needs to talk about beliefs and your conscience, these things. So this is like King David said that it's a light to our path. It shines inside of me in the sense that exposes things that I need to make changes in personally, even as a politician. Just as a variety of things, it shines, and I think that we just need to reflect here. As a society, as a government, as the House of Commons, as parliamentarians, about the contributions, and I'll make reference here specifically to Christians, of just the contributions of of the faith, the Judeo-Christian faith, and I know there obviously others can speak to other faiths, but the contribution to society, to the very foundation of who we are as a nation. And yes, there's blemishes. People are people. I don't care what faith you subscribe to. But at the same time, you look at the importance of the Christian faith in terms of education. I was a teacher for many years and taught socials and history and looked at medieval Europe and just the importance of for example, the monastic schools where there was no education of the training of the system of our hospital system. Think of Red Cross, that comes from a faith background. Florence Nightingale. I think of Salvation Army. Probably the other members met with the Salvation Army when they're here on the Hill recently, talking about the influence that they've had, what the giving they've had as far as helping those who are in need, emergency services. It's amazing the work that they do. And from a secular, non-religious point of view, I think we all would say this is very commendable. But they're very clear. They say it comes from a faith position of service. And I think that what is core, and this is what the challenge that I would say Christians feel. I think Christians feel like they're a punching bag, and what's so important to realize that so many of our perspective as a culture has come from a Christian foundation. Even the equality, for example, of men and women. That was not something that has always been there. But in the scriptures, it talks about no such things as man and woman in the sense, not in biological sense, but in terms of equality before God. So it's always been a source of equality. I would say even those that can say they might be feminists. Some of that might come from a biblical perspective in the sense that the equality, not subjugated under men, but equal. And that isn't everywhere. And then I think about the whole issue of slavery. Christians involved in that. I think of Wilberforce in the British Parliament. Decade after decade bringing legislation in order to stop slavery. And finally successful. And, there's a song we've all heard. I'm sure you hear it with the bagpipes. What comes to mind? Amazing Grace. Amazing Grace, written by John Newton in the 1700s. He was a slave trader involved in trade and capturing slaves in Africa or in the transportation from there to the New World, imprisoning them, shackling them. The terrible things. And what happened to his life? What happened to him? You read the song. What does it say? Amazing Grace. How sweet the sound. Sorry. That saved a wretch like me. And I guess I'm choked up, because it's not just him. It's me. It really is. We all need saving. As far as I'm concerned. Sorry, I've just put that out there. It says, Amazing Grace, how sweet the sound that saved a wretch like me. I once was lost, but now I'm found. Was blind, but now I see. And you see the transformation of his life. The transformation of his life from someone that is that position as a slave trader, as an evil person, and able to be transformed. And that's the message, I would say, of Jesus Christ, of the Bible. And that's the difference that made me personally, and I'm speaking personally. There's a verse, I said this verse was made very much alive to me. I was in the military, it was in my uniform. And a verse that you probably may be familiar with. And the verse is what? The verse says, for God so loved the world that he gave his only son, that's Jesus Christ, that whoever believes in him won't perish but have everlasting life. And that can just roll off. But to me it struck, and I saw, you know what? He didn't just die for the world, he died for me. And it wasn't say, well, because I was doing this bad or that terrible. It was more made my attitude of selfishness, everything around me. And I guess that motivated me and motivates Christians and people of faith to realize that, I'm here not to give, just to give and under my own, just accumulating wealth and accumulating experiences, but I'm here to serve our community, our country. And I think that we're all here for that, right? We're here to serve our country. We're here to serve people. And that's what the word minister, you heard the cabinet minister, we're there to minister, to serve. And so that touched me in my life. It transformed me when I was still an adolescent, and has been directional in my whole entire life. And I can understand that, you look at the scriptures, and the scriptures were written over, we're talking 3,000, 4,000 years, a long time. And in a lot of different cultures, and we can look back and say, well, this here doesn't fit in and that doesn't fit in. But there's cultural, there's generational, there's a lot of things, and it really does come together. And again, as a Christian, I would say this, that it says that it's summed up in all one word. And it says God is love. In 1 John, it talks about that God is love, not just feeling love, but his whole heart. His whole heart, even in his regulations, even the rules, everything he has for mankind, even the structures, is out of love. And Christians, there's the Old Testament and New Testament, don't just we believe it's a whole, but Christ does clarify it right there. He says, you've heard it said, an eye for an eye. But I say to you what? If someone slaps you on the cheek, turn to him the other cheek. And if someone persecutes you, then don't return evil, but return good for evil. And so I'm saying that's transformative. That's transformative. And for us as politicians with our laws, with C-9, to say, well, this has to, take this out, take this in. There's actually a lot of correction within the scriptures itself. Not correction, but Christ explains a lot of that. And so I guess what I'm saying here, members of the committee, thank you for your patience and not making your interventions in this time. Which I know, just to take some thought and realize, let's pull back on this. Let's just pull back on this. And with my colleague friends from Quebec, I get it. My mom is French Canadian. I've lived in Quebec, and je sais l'influence de l'Église.
And I know what has been the influence of the church for centuries, and I also know that it was difficult. So, for many people, there is a certain amount of resistance, and I understand that, because the clergy was so strong, and now people want freedom, and so I get it. But it's also possible to strike a balance, and I think that, of course, already we have laws. So I don't think that we should go ahead with this bill. Thank you.
Thank you, Mr. Dalton. I'm looking at the clock. I'm going to suspend for question period. I'm wondering, I know, Mr. Gill, you're next in the batting order, but I'm wondering if now is the right time to do it rather than start now.
Just what time will we be back?
I think there's votes after, so as soon as either QP or the votes are done.
15 minutes after the final vote.
Whatever
Okay.
the last
Understood.
of those events is. Okay? All right, we'll suspend.
You like?
Yeah, I mean, if you can do it in 5 minutes, that's up to you.
I'll try for
Okay.
5, maximum
Well,
10.
trying is different than doing, so. I don't think anybody here has been this anxious to get to question period in a long time, so. But go ahead, please.
All right,
I'll give you 5 minutes, and then I'm going to suspend, okay?
Thank you, Chair, for giving me the opportunity to speak on Bill C-9 and the sub-amendments by Mr. Brock. Let me begin with the obvious. Hate is harmful, it is corrosive, it has no place in Canada. Anyone who has served in uniform, as I had nearly for 3 decades, has seen the damage it inflicts on families and entire communities. But here's the part that doesn't fit on a podium or a press release. You can't fight hate with slogans. You fight it with clarity, enforceable tools, and legislation that respects both public safety
and the Charter of Rights and Freedoms, and that is where Bill C-9 falls short. Police leadership, the Canadian Association of Chiefs of Police, has endorsed this bill. They believe it clarifies thresholds and streamlines prosecutions. That's fine. That's the lane they have chosen, and I think it's misguided. But what does the rank and file say? The men and women actually responding to the calls at 2 in the morning, they're telling a different story. And frankly, those who work the front lines often understand the operational realities far more than those issuing the press releases. Here are the concerns that they raise consistently, privately, and with far more candor than you'll ever hear at a podium. First, they say, we already have the tools, we just don't use them. Officers point to the criminal code, which I've used many times, and it covers intimidation, harassment, threats, mischief, incitement. These laws exist, they work, but they're underused, mainly because leadership is afraid of political blowback. Secondly, their complaint is that definitions in this bill are too fuzzy. Frontline officers know that one misread situation can turn their career into a headline. They don't want that. If the difference between a heated argument and a hate crime rests on vague language, they'll hesitate, and hesitation is the worst operational environment you can create for them. Third, the point to is if the command structure won't support charges under existing laws, why would they support new ones? That is not cynicism, that is their lived experience, and was mine. Removing the Attorney General's sign-off puts everything on us. That's their complaint. Without that oversight, the constable becomes the choke point and the political lightning rod as well. And finally, this bill risks policing feelings instead of conduct. I can tell you from experience, officers are trained to respond to behavior, not interpret emotional or ideological content in the heat of the moment. These concerns matter. They matter because if officers don't feel confident using a law, it won't be used. And if vaguely drafted legislation is used poorly, it becomes a flashpoint that damages community trust for years. Now let's talk about the communities this bill claims to protect, not the ones in the press releases, but the real communities. Faith-based organizations, churches, mosques, gurdwaras, synagogues have raised serious concerns. Many of them fear the law's ambiguity could unintentionally criminalize the wrong conduct or chill religious teaching and cultural expression that has never been and should never be criminal. Civil liberties groups have issued the same warning. The Charter protects freedom of expression, assembly, religion, and conscience. And when legislation uses broad language, those freedoms become vulnerable to selective or uneven enforcement. This is not a theoretical risk. This is Canada in 2025. Communities are more polarized, economic pressures are higher, institutional trust is weaker, and yes, government policies over the last 10 years have exacerbated those divisions. Rising affordability pressures, social fragmentation, and eroding public trust in institutions creates the perfect conditions for resentment, anger, and eventually hate to grow. You cannot legislate away the root causes of hate. You have to address them. We have to address them. And Bill C-9 does nothing to address the root causes. It broadens offenses, removes safeguards, and tests the limits of charter rights, all without fixing the underlying cultural and enforcement gaps inside policing itself. And here's the real-world consequence. If this bill is applied unevenly, if one community feels targeted or another feels ignored, tensions get worse. Trust erodes further, and the very hate we're trying to combat gains more oxygen. That is the danger of poorly drafted law in a fragile environment, which we are living in. And so, yes, we absolutely need to fight hate, but we need to do it with a clear, enforceable laws, proper training, proper resourcing, and the courage to use the existing tools we have. We need to address the social and economic conditions that fuel hate, and we need legislation that does not compromise the freedoms that define this country. Mr. Chair, Canadians deserve safety and freedom, not one at the expense of the other. Bill C-9, as drafted, does not strike that balance. The sub-amendment proposed by Mr. Brock is necessary to correct the severe imbalance of this legislation. The sub-amendments are fundamental to our society and our country. Thank you, Mr. Speaker, or Chair.
Okay. Much, Mr. Gill. Okay, we'll suspend now until 15 minutes after QP or votes, whichever is later.
Okay. I'll make a new link for us to come back to for that. We're going to switch over to question period, and if you want to stick around for after, I'll make a new link, and we'll come back to this, however long this lasts. I'll see you guys in 3 minutes. I'm going to switch over to the link for question period. I've put it in chat, but there it is again. And just before we go, I did say when they came up, but thank you, Megan, for the gifted memberships. Thank you, Nicole, for the super generous super chat. Thank you, Raven, for the super chat. Thank you, Fickle, for the super chat. And thank you, Luke, for the super chat. Everybody's feeling super generous these past couple days, which is always awesome. And yeah, I'll see you guys shortly for question period. 3 minutes. Well, 2 minutes now. See you guys in 2 seconds.